was pleased to allow their dismiss the application of the respondents, Your Lordship, we are the for the plaintiff, Your Lordship. On that day, Your Lordship was pleased to ask me to mention it separate day, Your Lordship, to get it listed, Your Lordship. So we are
Commercial
upon
matter?
mentioning notice, Your Lordship.
Commercial?
No, Your Lordship, it's not commercial matter, non-commercial matter, Your Lordship. Lordship on the pleased to pass this judgment on the last occasion, Your Lordship. After that, Your Lordship was pleased.
Acha, then. So this application was dismissed.
Lordship, our application for judgment upon admission is pending, Your Lordship. So
that is to be heard.
that is to be listed.
Who is for the other side?
I'm mentioning upon notice, Your Lordship. Mr. Dheeraj Gupta is there, Your Lordship.
Thursday has to be Thursday's practice and chutti hai na. Next Wednesday, Dr.
Deeply.
Your Lordship may be permitted to mention this matter. We needed leave to file this Order 7, Rule 11. The problem which is with respect to the department, what has happened is the department is saying various pages, around 40-45 pages of the annexures of the plaint, they are illegible. Now, I am annexing because in Order 7, Rule 11, I have to annex the plaint with the annexures. I am annexing what I have received. Now, I really don't have a choice other than to annex that. How will I replace those pages? I don't have the originals of that.
Plaint admitted.
Plaint admitted. Commercial suit.
Notice served.
Notice served. And that it's appearing in the list also, Your Lordship. That plaint is appearing in the list also.
In the plaint, that is not a legible copy.
Your Lordship, the one which we have annexed, is the one which we got.
No, that's why the plaint which you have received, that is not the legible.
That is what the department is saying, that so there are some pages which is not properly legible.
Have you informed to the other side?
No, I have not. Yeah, I just wanted to leave to file Order 711, Your Lordship.
Leave is not necessary.
No, it is, because otherwise they are saying that you replace these pages.
With regard to the legible copy.
Legible copies of the plaint. That is the problem, Your Lordship. Otherwise,
but how if it is not legible, how you will argue and how the court will?
Your Lordship, that is a different point. That I will come to that. But this is only a pure question of limitation. So I don't really need. It's all.
Order 7 Rule 11. What is the limitation?
Your Lordship, it's complete question barred by limitation. But on the face of it, Your Lordship, 2018 transaction, 2013, 23, it has been filed.
That is a plaint.
In the plaint. Your Lordship, whatever it is, I will satisfy Your Lordship on the face of it otherwise, but I just, at this moment, I needed the leave to file. I am not being even allowed to file because the plaint has some copies which are illegible.
So you give the undertaking, legible copy will be filed.
How will I file?
That is the problem.
That is a problem for me. I have been served with something.
Matter is listed in the commercial matter.
It's a commercial. I don't know today's number, Your Lordship, but it is there. Yes. Maruti Packages Private Limited. It's undefended suits in, it's number 1 or 2 of the ID.
Undefended suit.
Yes. It was there in Friday's list. Friday list. It was in the list.
अच्छा की है क्या नहीं है you do one thing, you give the case number.
Yes, Your Lordship.
Give the case number, it will be listed. Then I will check the paint. If it is there, then I will grant you.
Very well.
Give the CS number. It will
yes,
be
I'm just my clerk.
Listed, then let the record come. Then today's 46. Okay, come at 2. We'll see to that.
At 2. Not sure. No, Maruti Packages.
No. Okay, you give the number, it will be listed.
Lordship, may I have your Lordship's kind leave to mention item number 27 of today's list. Lordship, the plaint was presented on last Friday. It is with utmost urgency. We are moving this ad interim application for injunction against the defendant, as well as appointment of a receiver, Lordship, injunction restraining him from using my registered mark. Lordship, though it's in today's list, Lordship, our only apprehension is it's considerably down. So if your Lordship can fix it anytime tomorrow, convenient to your Lordship.
List tomorrow can't be. Tomorrow is the
Lordship, it is with utmost urgency that we are moving.
That's why it is today's list. If it is reached, it's okay. And otherwise, you mention, we'll see to that.
Okay, Lordship.
It is in the list.
Yes,
we can't say whether the week. I don't think we cannot reach that item 27 today.
Lordship, We will mention.
May I have my lord's kind leave, my lord, to mention, my lord, GA number 3 in 560, CS number 565 of 2024 and GA number 3 in CS number 564 of 2024. Now, my lord, your lordship was pleased to take up this matter on Friday, my lord, 9th of August, and had been pleased to fix the matter post exchange of affidavits on 30th of August, my lord. Now, my lord, on 30th of August, I'm in some personal difficulty, my lord.
564, 560, what is,
Suit number, my lord.
there is an interlocutory application.
The interlocutory applications are made returnable on.
Judgment upon admission.
My lord, no, that's, my lord, the application for extension of time to file written statement. My lord, Mr. Dashgupta.
GA3 is
GA3.
my learning secretary's application. GA1 was my application. GA2 was his
Judgment upon
application.
admission, your lordship rightly recalls, my lord, Mr. Banerjee was reading me.
Yes.
That
yes.
is a 564.
That same suit, my lord, that is in that
564,
564, 560.
iron ore matter.
Iron
Yes,
ore
my lord,
matter.
iron ore.
Now, my lord, in that matter, I have taken out an application, my lord, for extension of time to file the written statement. My lord, your lordship was pleased to take up the matter on 9th and thereafter fix it on 30th of August. My lord, I was humbly seeking your lordship's leave, my lord, if it could be fixed on any other day. I've informed my learned friend on the other side. On 30th of August, I'm in some personal difficulty.
At
That is the reason.
first week of September or second week?
Anytime. I'll come back.
Okay, you do one thing. If you're not able, any of the junior, you will be there.
Yes, my lord.
Inform them, I will fix the date.
Very well.
I
Because
know
it was
nothing
my
because-
duty, my lord, to
No
indicate. my
problem,
lord.
because I think the file is in the chamber for dictating the judgment in order to 7 rule 11, that judgment upon admission.
Judgment upon it.
That is concluded.
Yes.
Yes, but my lord, this is a fresh G.
That's on
Very
the 30th, he informs
Very,
any of the junior mention. that
Very,
is fine.
very. That's why, my lord, I mentioned it before. Grateful, my lord.
Grateful, my
Deeply
lord.
obliged.
May I have your lordship's kind leave to mention one matter, lordship? Lordship, by an order dated 14 June 2024, lordship, my lord was pleased to grant the plaintiff the leave to amend the plaint within a week. And pursuant to this order, lordship, we have already amended the plaint. Now, my lord, this matter will be placed before the learned master for admission, since there is no leave has been paid in the plaint, lordship. The amendment has already been carried out, my lord.
So what is the suit is not yet presented?
Yes, lordship.
List as a presented. What leave you have prayed for?
No leave has been
So
paid.
place before the master.
My lord, a direction may be passed by my lord so that we can
Unless the file is not there.
let it be listed under to be mentioned, lordship, tomorrow.
Once you amended the plaint,
Otherwise, you have to-
automatically it will go to the master and the master will see. How the court can call the record unless it is not been admitted?
Lordship, I'll
Request the department to place, if it is not, then you mention the matter.
Lordship, grateful, man.
We mentioned item number 1.
Please, my lord. Please, my lords, I beg to appear online in this matter, to lordship's indulgence.
Yes.
Lordship, this is a matter in which, in fact, what is listed before my lords is AID number 18. But actually, my lords, there is another matter. The same matter is actually also IPD PTA 34 of 2022. With a order, my lords, of your lordship's predecessor, bench dated 19 January 2024. What has happened is, my lords, this IPD PTA 34 of 2022 has been restored because there were duplicate appeals. When the IPAB was abolished and the papers had not yet moved, we had moved the AID, so that now stands withdrawn and taken up on board, my lords. This is IPD PTA 34 of 2022, which stands restored with a order dated January 19, 2024.
What is the 19 January order?
My lord, I have a copy of the order.
My friend has a copy. I'm sorry.
The order take to the
19 January order.
1st December order.
19 January.
1st December.
He's telling the 19 January.
So 1st December.
All right, 1st December, my lords. Because it was restored on 19 January, I think, if I'm not wrong. So I have a copy of the 19th January order. It was restored on 19th January 2024.
Finally, it was restored on 19th.
Correct. The dispositive order, my lords, restoring the IPD PTA is 19th January.
19th January. 19th January order টা লাগাস নি তো?
टेक्स्ट ओपन करके आपके कंप्यूटर
देखिए मुझे बाहर पड़ा सॉफ्ट कॉपी टे पास है मुझे देखिए ওটা AID IPDTA 434 এ থাকবে এই ফাইলটাতে মনে হয় থাকবে না My lord, that order will not be in this file because that was the AID IPTTA 34 it was restored, so that file is not here, so my lord will not file.
AID is connected with that.
AID lordship we had filed. What had happened is, I'll just with the leave of Mr. Ramanujan, AID 30 AIPDTA 34 this was earlier pending before the learned IPB Intellectual Property Appellate Board. Thereafter, what had happened, that file had not come here. So correspondingly, that same impugned order we had challenged in this AID 18. Now, what had happened, Lordship may kindly look at the order dated 1st of December. My Lord Justice Mukherjee has recorded that the both are same. So we may take steps to restore AID 30, AIPDTA 34. We have taken steps. It has been restored as well. That is not appearing in the list, my Lord. So this AID 19 it's the same, the impugned orders are same in both the matters. So we had rather not press the AID because the appeal is
The appellant has taken.
yes, AID has also been disposed of.
AID inter alia probably transition. So what is the 5th January order?
5th January
19th January.
19th January, but that will be in IPDTA 34 file.
That perhaps my lords do not have the file today because it is not on the list.
It's not in the list.
I have the order.
34 এটা?
I have 34. I have the online order.
Lordship, I have a soft copy, my lord. হ্যাঁ 19 দিয়ে দিয়েছে
But no order is passed with regard to AID. On 19th.
My lords, once the IPD TTA is restored and taken on board, the AID need not be retained, my lords.
That's correct because this court was of the same view, but on that 1st of December, your IPDTA was dismissed, so that this court has not passed any order on 18. Now,
Precisely, my lord.
January, your appeal was restored.
Precisely,
IPDTA 34 is restored. Now, what is your submission? Whether you will not press the AID?
Precisely, my lords. We will press on the IPD PTA.
Okay.
And your lordships may dispose of the AID, saying that because we are pressing the say IPD PTA, this may not be taken.
Okay. You are appearing?
My lord, I am appearing for the respondent controller.
What is your submission? Any
We are agreeable to this one.
so and so appearing for the appellant, so and so appearing for the respondent. Full stop. It is submitted by the learned counsel for the appellant that after the amendment in the in the law, the appellant has preferred an appeal being IPDPTA 34 of 2022. IPDPTA 34 of 2020. Full stop. But unfortunately, the same was dismissed for default. But subsequently, by an order dated 19 January 2024, the appeal being IPDPTA 34 was restored. It's restored. Okay. Full stop. Now the appellant submit that AID is AID number 18 of 2022 is also connected with the similar order, and as such, the appellant do not want to press the AID 18 of 2022 and intend to proceed with IPDPTA 34 of 2020. In view of the submission made by the counsel for the appellant, AID 18 of 2022 is dismissed as withdrawn on the ground that already appeal has been admitted against the same order being IPDPTA of 34 of 20. Full stop. Echo. In view of the above, AID number 18 of 2022 is dismissed as withdrawn. Consequently, the connected application in connection with AID 18 of 2022 also dismissed as withdrawn. When the date is fixed, IPDPTA?
There's no date fixed, my lord.
There's no date
Item numbers 1, 2, 3, and 5. Mr. Ramanujan is appearing. I'm assisting Mr. Ramanujan. If all the three, because he's coming, he'll be coming from Delhi. If
all connected matters.
Not connected matters, my lord, but those
Neighborhood
are
orders. As my friend says, the only connection, my lord, is I am appearing in all. That's
yes, my
all.
lord. That is the only connection.
Okay. So,
subject to your lordship's convenience, it could be, my lords, put up on 25th of September, subject to your lordship's convenience.
with regard to the IPDPTA, let it be fixed on affidavits have been completed.
Lordship, records have to be called appeal. So order for records.
Order
If
for
it could be
records.
placed in,
Let IPDPTA be listed as to be mentioned on Friday.
Lordship.
Full stop. In view of the full stop. As an learned counsel for the party submitted that no date is fixed with regard to the appeal being IPDPTA 34 of 2020. Accordingly, let the said appeal be listed on
My lord, may it be Monday, my lord, but Friday I'm not in Calcutta.
on 19th August 2024 as to be mentioned.
Grateful, my lord.
Obliged, my lords.
To be mentioned for fixing the date for hearing of the appeal.
Highly obliged, my lords.
Yes.
My lords, I'm sorry.
My lord, we have not been served the IPDPTA copy.
That's why
lord.
I'm asking. That's why you're not fixed the date. Let it be come on Monday. If you are not been served, then I'll pass appropriate order. Whether
As
the
a matter
paper
of fact, Lordship, we
whether
do
the
not have
paper
any
book is
copies.
required or you will file affidavit in opposition. Let me see. Then I will fix the date.
এখানে কি করে হবে?
Because without the record, it cannot. Yes. Next.
Number 2.
Please, my lords.
Hearing on behalf of the controller, ma'am.
Yes.
I appear in this matter. Your lordships will note, my lords, in this video, your lordships predecessor's bench's order dated 1st December 2023.
AID.
Yes, precisely, my lord. This is AID.
Yes. So
My
now
lords, the delay has been condoned. And my lords, in
There was a
AID
direction
19,
for
my
filing
lords,
affidavits.
have you filed?
No, no. We have served.
Have you received the copy of affidavit?
No, no, Lordship.
Yes, your lordship. I have served them. You have received it.
Please
check করে নিচ্ছি 19 AID 19 আচ্ছা আচ্ছা পেয়ে গেছি আচ্ছা
Will you
Well, I
file
was going-
reply? Will you file reply?
Lordship will file a reply.
We'll file a reply, my lords. Your lordships may just give us 2 weeks time. We'll file a reply. And this may subject
for the plaintiff, not appellant. So appearing for the respondent. The respondents have filed their affidavit of opposition after serving the copy to the learned counsel for the appellant. Let the same be kept with the record. Counsel for the appellant prays for time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks. List the matter on
subject to your lordship's convenience, my lord, September 25th, my lord, so that I can come physically, my lords, to your lordship's.
so paper book is not required.
Well, I think the paper book, my learned friend will have it ready, my lords, for the next day.
Paper book will get it ready. Paper book will get it ready, but the department has to transmit the records. Without the records, the appeal cannot be decided.
No, whether the record has come from
Record
the
has, there was no direction to transmit the record, so if
The-
direction may be passed.
the registrar who has passed the order.
ठीक है, इसको last order.
Who has passed the order?
Pilot Justice Arindam Mukherjee had passed
No, the impugn order.
Oh, impugn order.
Patent office, my lords.
The designation.
What is the designation? There is a difficulty. Otherwise,
Oh, I'm so sorry. My lords, let me just point out. My lords, the
assistant controller.
assistant controller.
क्या बोल रहे? Registrar controller and the registrar patent and design, Kolkata is directed
controller
to transmit
direction
the record of application number, patent application number 1481/AOL NT/2014. First item. 14. In the name of dated 15 July 2014 in the name of Deccan Deccan Industries Limited. Before the court within 2 weeks from the date of receipt of this order. The counsel for the appellant is directed to communicate this order to the registrar patent and design for compliance.
But it's subject to correction. It is the controller of patents.
Well, it appears that the assistant controller is not even a party, Malad.
That's
Lord,
why I'm saying.
Lords, if I may submit, your lordships will see under the Patents Act, the assistant controller is exercising powers of the controller. So, my lords, the controller is actually the person who it is being issued. The order is always issued in the name of the controller.
The controller may be directed. Respond number 2.
Control, not the
Controller may be directed.
Controller General of Patent and Design and Trademark. Controller General. That's why I asked you twice. He's not a party here. The Controller General of Patent and Design and Trademark.
I'm grateful, my lords. Right.
Returnable data problem.
Yes, next.
20th.
What is the date? Date given. List the matter on 25th
September.
September.
I'm so grateful.
25th September.
Wait, please, my lords.
I will
this
be
is-
the respondent, my lord. My lord, for respondents, my lord, I am appearing.
Yes.
Lordship, I am led by Mr. Singhania.
What is in the matter? Condone, delay condone.
No, your lordship.
397 days delay, my lord.
Not condone.
No, your lordship.
Delay is not condone.
No, your lordship.
No, not yet.
Lords, the application is pending. Just slowly.
It's 397 days.
Where is the
Yes, my lords. Your lordships will see your lordships will take up my GA on the subject of condone delay. GA number 1 of 23. Lordships may kindly have paragraph number 2 onwards. I hope my lord has that application. GA number 1 of 23.
Yes, Mr. Singhania, you will file affidavit or
Your lordship,
Affidavit
the
has been filed,
affidavit is
reply also.
filed?
No, your lordship, it is ready, your lordship.
No, no, affidavit is ready.
My lords, may I only say this? Your lordships will have the order dated 20th April 2023.
Maybe they have filed a writ earlier and it has been withdrawn. Now they have come with this application.
My lords will see
With
the
regard to
order
now
dated.
397 days, have you filed the affidavit, Mr. Singhania?
Yes, my lords, we have. Yeah, I'm so sorry. I'm sorry.
No, my lord, the GA1, we have not filed, my lord.
You're not
I
filing.
would like to file, my lord, against this.
That's the point, my lords. 20th April 2023, almost a year and a half back, a direction was given to file a counter. We have lost 1 year just in arguing the condone delay application, my lords.
There is a direction.
No, my lord,
Yeah,
there is
my
no.
lords. Please have, my lords. 20th April 2023 by Honorable Justice Ravi Kishan Kapoor, my lords.
Where is the order? 20th April.
Yes, my lords.
Yes.
There is an application. Respondent represents seek opportunity to file. Let the affidavit in opposition for 2 weeks. Reply within. Yes, 20th April 2023. There is a direction of 2 weeks, Mr. Singhania.
No, my lord, against the main application, my lord, we have filed it. Main application.
So they do not oppose the condonation of delay.
So
They don't oppose.
No, my lord, we are opposing, my lord, we have to file
you
it.
have not filed the
How can
affidavit.
we oppose after filing opposition?
You have
to
not
main?
filed the affidavit. You have filed the opposition to the main application.
My
Let the
reply is
main
ready,
application-
lordship,
the
with
main
their opposition.
application be taken up for hearing, condoning the
Precisely, my lords.
Yes.
Precisely,
My
my lords.
reply is also
My lords,
ready against their opposition.
Then your lordship will decide, my lord, then
Your
397
lordships
days.
may condone the your lordships
No.
may therefore condone the delay. The reason, my lords, is I understand why they have not opposed it, because this is an order passed during COVID period. And your lordships will recollect, because of the Honorable Supreme Court suo moto order, up to 2022, I'm covered by the suo moto order.
Up to
And my
February
lords, after that,
2022.
and my lords,
Up to
after that,
February
we
22.
had and after that, my lords, we had moved a writ petition challenging the impugned order, which was withdrawn with liberty to pursue an AID. Your lordships will therefore see from my para 2 onwards, from para 2 to
But you are not enclosed the order of the High Court. Where is the order of the High Court?
Mr. Munda perhaps is carrying a copy of the order of the High Court, my lords, because it's a judicial order. Perhaps it was just carried in hard copy, which is the order dated 18/7/2022 in the writ petition.
Lordship, I apologize, Lordship. I'm not carrying the order.
Not have neither you annex nor your advocate is having the copy of the same.
I'm so sorry, my lords. That is an oversight on our part. We should have been more careful.
So what
My lords, your lordships may still consider my affidavit for a moment.
No, affidavit can be considered, but you rely upon the judgment of the Supreme Court, and because you wanted to take the benefit of Section 40 of the judgment of the High Court. That was on 18 July, when the when your liberty was given to file an appeal. By which order?
18/7, my lords. 18/7,
July.
my lords. Yes,
18
my lord.
July.
18 July 22.
Ah.
And the certified copy of the impugned order was reached at 10th November 22, and the appeal was filed on 9 December 22. Your lordships will have para 7, 8, 9, 10 of my affidavit.
Why 8 July order was there and you obtained the certified copy on 10th of November?
Lords, because when we filed the writ, we had not taken a certified copy. We had gone by the web copy of the order. But because the rules, my lords, require a certified copy, therefore we moved a certified copy application thereafter.
Lordship, I'll be very candid, Lordship. These companies, Lordship, are actually based abroad, Lordship. There were certain practical difficulties from our office's end and the Advocate on Records office's end and the office of the client, Lordship. That was the reason. I'll be very candid with you. I will not
taken that ground, sir. You have
very embarrassing, Lordship. I can
that's why
understand.
you have relied upon the judgment order of the writ court dated 18 July, and you filed the present appeal on 19th of December, 9th of December.
Lordship.
after 5 months.
Lordship.
And now you are taking that the certified copy was granted on 10th of November. So
Lordship.
when you applied for the ban, with regard to the condoning the delay, only you rely upon the copy of the order of the High Court. Certified copy is not required. Website copy is available on the very second day.
No,
Where is the justification on that?
Your lordships may only consider then, my lords. Let us also file an additional affidavit if for your lordship's satisfaction, my lords. We will also include all these factors, my lords.
7th July. This is
18th July, Lordship. After soft
18 July.
soft copy.
liberty to देवा yes.
Liberty is given to file.
That's correct. I am not telling that no liberty. 18 July liberty was given. And when you file this appeal,
After 5 months,
you know,
after 5
December.
months.
And for filing the appeal, filing the section 5 application, certified copy is not required. And you have not made any further averments. Why this 5 months delay? How the court will accept this?
My lord.
Lordships may have, my lords my lords, my friend is right. Your lordships may just give us the liberty. We will move an additional affidavit, my lords, to support our section 5 application. My lords, we are only in the interest of justice, my lords, because the statutory right should not go away. My lords, permit us to file an additional affidavit, my lords. We will clarify the reason for the 5-month delay.
But the latest judgment, you know, section 5 after filing of the appeal, filing a section 5 will not solve the purpose.
Yes.
My lord, we pray on your good conscience.
We only, my lord, bow down to your lordships on that.
So appearing for the appellant, so appearing for the respondent. Counsel for the appellant has filed an application being J1 of 2023. Praying for condoning the delay of 397 days in preferring the present appeal. Police counsel for the appellant prays for leave to file supplementary affidavit in connection with J1 of 2023. Let supplementary affidavit be filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on
Same day, my lord, 25th September.
25th of September 20.
My lord, we have our reply to their main opposition is ready. If I may allowed to file along with the affidavit of service. Lordship, they're filing a.
When the GA1 is allowed, then only it will come, my lord.
But you have filed what can be done?
Yes, I filed, my lord. At that time, this application was not there.
In opposition of the appeal, after serving the copy to the learned counsel for the appellant, police appellant has filed affidavit in reply to the affidavit in opposition. Let the same be kept in the record.
Grateful, my lord.
Grateful, my
lord, item 4, your lordship, I appear for the plaintiff. My lord, this is an application, my lord, for rectification of the registration trademark. My lord, actually the matter was filed before the Deputy Registrar Intellectual Property Appellate Board, Chennai, from where, my lord, the matter got transferred. And when it was transferred, my lord, the plaintiff was not aware of, and the matter got, my lord, dismissed for default. Pursuant to which, my lord, by an order dated 25th August 2023, the matter was, my lord, restored by the Honorable Justice, my lord, Arindam Mukherjee. My lord, as I am, my lord, aware of, my lord, the service was not complete upon the defendants. And my lord, there is no injunction interlocutory application separately injuncting the respondents not to use the, my lord, impugned mark.
So whether this
So,
is
my
appeal?
lord, I will be
Is an appeal?
Yes, your lordship. It's a rectification application, my lord, for rectification of the registration mark of trademark, which was filed in the name of the respondents number 1.
Correct.
So, my lord, it has to be served, my lord. It has not been served as of yet. No, not served, my lord. So, my lord, if an order be made, my lord.
Where is the order of restoration?
My lord, order of restoration is dated 25th of August 2023, passed by the Honorable Justice Arindam Mukherjee.
It is not on record. None of your junior is here to give the copy.
My lord, no, I am extra. My lord, I will supply the copy by today only, my lord. I'll supply to your office, to your lordship's offices, your lordship.
Come on Monday with the order.
My lord, Monday I'm not there. If tomorrow, subject to your lordship's convenience.
Tomorrow is a non-commercial day.
My
Touching
lord.
it, right?
My lord, I can tell your lordship, my lord, the date of the order. It's on 25th of August 2023.
25th of August.
Yes, 25th of August 2023. The matter was, my lord, restored. Your lordship, by Honorable Justice Arindam Mukherjee.
Just a minute, just a minute. Census and appearing for the appellant. Will the counsel for the appellant submit that? The copy of the appeal has not been served upon the respondent. Only one respondent. How many respondents?
Man, 1 and 2, 1 and 2, 1 and 2.
Respondents.
1 and 2, your lordship.
Submission made by the counsel for the appellant. The appellant is directed to serve the copy of the appeal along with all documents to the respondents within a week from date. Please the matter on 27th of August 2020.
Very well, your lordship. 27th of August. Deeply obliged, your lordship.
Next.
Your lordship places, my lord, because this is also a statutory appeal from the Controller General of Patents, my lords. And in this, my lords, there is a GA1 of 2023 again seeking a condonation of delay of 71 days. And my lords, today, your lordship's predecessor bench's order, this is Arindam Mukherjee's order dated 8th December 2023, my lords. R1 and R2 are not opposing. They have not sought, my lords, and R3, my lords, was unrepresented on the last occasion.
Direction was passed upon us to serve them, lordship. We have filed. This is the affidavit of service.
Affidavit of service, my
But
lord,
I'm appealing for respondent number 1 and 2, my lord.
Yes.
I leave it to your lordship, my lord. 72 days delay, my lord. I leave it to your lordship. And private respondent is also there here. Respondent number 3 is the private respondent, my lord.
Who is appearing for the private respondent? Nobody. Have you served to both? Have you served
Yes,
to both?
Lordship,
yes. The affidavit of service, my lordships may take on record. My lord,
this is the second affidavit of service. The earlier affidavit of service we have filed the office of the patent controller. This is, my lord, pursuant to the direction passed by my lord Justice Mukherjee.
On
8th December 23.
Since appearing for the respondent, the appellant has filed the application being GA1 of 2020 saying for condoning the delay of 71 days in referring 72 days in referring the appeal against the interim order dated 31st of March 2023 passed by the Assistant Controller of Patent and Design. Who has passed the order? Respondent.
Assistant Controller, my lords, R2.
So consider the submission made by the counsel for the respective parties, peruse the application, find the sufficient cause has been shown for not filing the appeal within the prescribed time. Accordingly, delay of 72 days in preparing an appeal against the order dated 31st of March 2023 is allowed. GA 1 of 2023 is disposed of.
My lord, if I my lord, I'll come. My lord, if I may suggest, lordship, in this matter, since the delay has been condoned, on the 25th, if a time is fixed, lordship, for hearing of the main appeal after
Whether you will file affidavit?
No, my lord. In main appeal, we do not want to file affidavit.
What about the private respondent? They are not. You are appearing.
I'm from the respondent number 1 and 2.
Appeal is admitted.
Let the private respondent be served again, my lord.
Has none.
Not an issue.
Already served them.
None of
Please serve it
the
again.
private respondent, the appellant is directed to serve the copy of the appeal along with the document to the private respondent and to file affidavit of service on the next date. Please the matter on 25th of September 2020.
My lord, if a time may be fixed for hearing, lordship.
Grateful. That will be first.
About
Yes,
Grateful. Grateful.
Lordship, I beg to appear on behalf of the petitioners in item number 6, your lordship. It is appeared at our instance for corrections, your lordship.
At page 2, Your Lordship, the third paragraph where it has been recorded that the alleged contemners had paid 3 crores 50
That
lakhs.
is, that should be mentioned on the prayer made by the council for the. It
Should be
in correction, for correction in the order dated 6th of August 2020. Council for the present submitted in the order dated 6th of August 2024 in page number 6. In page number 2, the fourth paragraph, 11th line, the amount has inadvertently recorded as 3 crore 50 lakhs 3 comma 50 comma 00. But it should be only 3 crore 3 comma 000000. The council for the plaintiff petitioner further submitted in page number 3 in last paragraph, line number 1, along with the police of Tirupati, the police of Tiruvallur district is also to be added.
Lordship, it should be district collector and police authorities, Tiruvallur district.
In view of the submission made by the council for the plaintiff in page number 2, paragraph 3, line number 4, article 11. The amount shall be read as 3 crore, and in page number 3, in the last paragraph, shall be read as the district collector and the superintendent of police of Tirupati as well as the Tiruvallur district, Andhra Pradesh. This is Andhra Pradesh, Telangana.
Tamil Nadu here, sir. It should be Tamil Nadu.
Tirupati,
Andhra, and Tiruvallur district, Tamil Nadu state.
the superintendent of police Tirupati, Tirupati district, Andhra Pradesh, and the district collector and superintendent of police Tiruvallur, Tamil Nadu, shall render all necessary assistance to the receiver for taking symbolic possession of the above mentioned property. This order may be incorporated with the order dated 6th August 2020.
Obliged, Your Lordships.
Next.
All right, item number 7. This is my appeal under section 117A of the Patents Act. My lord, originally filed before the IPAB, appearing for the second occasion. My lord, no opposition direction for affidavits were given. My lord.
File affidavit. File affidavit. Yes.
Have you received a copy of the appeal?
Yes.
My lord, only one thing I'd like to indicate.
Private respondent?
My lord, there is no private respondent.
No private respondent.
No, my lord. This is the order passed by the assistant controller, who is the respondent number 2, and the controller of patents is the respondent number 1. But only one thing I'd like to indicate, my lord, this is the e-cigarette related to e-cigarette matter which your lordship was hearing. My lord, your lordship directed on last occasion when the matter is fixed. It fixed on 23rd of this month, my lord.
But how it can?
It cannot be, my lord. But only your lordship wanted to know.
23rd.
23rd of this month.
But why you have made him by name as a party?
My lord, this was originally filed before IPAB. I have got nothing to do, my lord.
And the second thing, this assistant controller of patent.
Yes, my lord.
It is a regular employee or contract employee?
I have to take instructions. Sir.
I believe it's a regular employment. Regular
employee.
employee.
I have to take instructions. Even in the previous matter, my lord is the assistant controller.
Because if it is not a regular employee, then there will be a difficult.
Another thing, my lord, possibly they have filed an application, but I don't know, the format is a bit different, my lord, in IPDT.
That is appeal in the IPBA.
Yes, my lord.
But my lord, possibly they have sought for extension of time to file appeal. So condonation of delay is possible.
Condonation delay?
Possibly.
No, there is no such application. My lord, Mr. Basu is leading. I'm sorry, my lord. Traffic diverted completely. In a sudden manner, traffics have been diverted from red road.
Yes.
Paragraph 53.
Now, the order dated, this is order dated 19th of September 2019.
My lord.
This is the imping order.
Yes.
19th September. 19. And when the appeal was filed before the IPB?
In their application, page 50, paragraph 53.
53?
Yes.
Due to insufficient time to analyze the facts and circumstances content of the appeal.
So where the appellate is compelled to seek extension of time to file appeal. And thus a formal request on Form 3 and the
It was
requisite
filed.
fee
It was
has been-
filed. That was filed before IPAB.
So in effect, it is an application for condonation of delay, as far as I understand, my lord.
No, my lord, I think, my lord, what's happens is, my lord, before the IPAB, my lord, there was a condonation of delay and the appeal is in a composite manner.
Now,
Yes.
that's why
That is the-
whether the IPAB has condoned the delay.
No, my lord, in no proceedings, my lord, ever was listed before the IPAB. It has come before your lordship
Then
for
you
the
have to
first
take
time.
steps.
Yes.
Because it was filed when you filed the appeal before the IPAB.
Yes, it has to be filed, I believe.
It was filed on 3rd of February 2020.
Yes, yes.
And the impugn order is
19th September.
September 19.
Yes.
90 days
90 days.
delay.
Hmm.
So,
We've come up with an application, yes.
so and so appearing for the appellant, so and so appearing for the respondent. Police. The counsel for the respondent has pointed out paragraph 50, 53 of the appeal, wherein the appellant has seek an extension of time to file an appeal. Learned counsel for the appellant submitted that this appeal was filed before the IPAB, Intellectual Property Appellate Board, IPAB, and before the IPAB, that was the procedure. Only in the application, the appellant can seek extension of time to file appeal. Now, as per the amended act, after the amendment, all the appeal has been placed before this court as an appellate authority, as appellate court, and accordingly, the petition and the appellant raise for time to take appropriate steps for filing an application for condoning the delay, for preparing an appeal against the impugn order. In view of the submission made by the counsel for the appellant, is adjourned for 2 weeks for taking appropriate steps. This the matter on 30th August 2024. 30 August you take instead.
Well, we file an application.
Take I on for taking steps.
Wait.
Item number 8.
And after the respondents.
Item number 8, my lord, I appear for the respondent number 3.
Hmm.
Lord, I believe
the delay of 89 days, which has
And,
to be condoned.
And the only thing, probably completed copies of the application has not been handed over. I can. Commissioner Shoya.
my lord, I appear for the respondent number 3, my lord. May I be permitted to file an affidavit
For
the application for condonation of delay? If your lordship
condonation of delay 79 days.
79 days, lordship will see the explanation, my lord. 23rd January order, my lord, certified copy applied for in lordship will kindly see paragraph 8. Certified copy applied for in May.
What is the order dated? Impugn order dated?
23rd January 2023. 30th January they received the copy.
Yes, it is from the date of service of the order.
Very well, my lord. 30th January and
Now your
certified copy of
paragraph, my lord, 5, paragraph 6, and paragraph 8, my lord.
And led by Mr.
But in fact, it is 55 days.
Delay may be condoned. Both happen. Delay may be condoned.
In fact, it is 55.
Yes.
Yes, my lord. Lordship will kindly see the explanation given, my lord, in paragraph 5.
That is
for
correct.
Written submission physical inspection of the file was taken, my lord, for written submission, and then but I am opposing this application, my lord. I leave it to your lordship. Lordship will kindly record my.
I am not opposing. I do not oppose section 5.
A sporting person.
Well, it may bite me back.
But I was hoping Mr. Basu was stuck more in traffic.
So you will take advantage of it.
Sense appearing for the appellant, sense appearing for the respondent. Okay, sense appearing for the respondent.
The opposition is out.
Respondent number 2. Who is
Well,
for the
I appear for the respondent number 3.
Well, I think they are
1 and 2. They are 1 and 2.
You are one. Then appearing for 1 and 2. Sense appearing for the respondent number 1 and 2. 2 hearing officer.
They have named the hearing officer.
But again, here the problem.
Yes, my lord, that will be a problem.
Yes, I had mentioned it, but taking that point only. It can be set aside and disposed of now
No,
itself.
I think that have instructions from the ministry. I think
yeah.
ministry has also taken a decision. This all contract worker cannot do that.
On the basis of visa international.
I have to take that as well.
Your show cause, na?
IQC, they are not the government authority. On the basis of their recommendation, this persons,
So they were
the
show
persons
cause.
who have been engaged on contract basis cannot deal with this.
No, they
matter.
can't.
I
I
think
have to
ministry,
take that instruction.
just I think
So they have been show caused by the
10, 15
DPI.
days before the ministry has taken a decision also.
Yes.
My lord, I believe it is the same person as your lordship passed an order.
Ah,
in
servant
the visa internet.
Same,
It's
same.
the same person who has passed.
If
The
it
same
is there,
named
then my
person.
lord.
Same person. Hearing officer.
My lord,
No, even though
condolence,
no,
No, if a
not-
notification comes from the ministry,
that's the notification come. That's why Mr. Bachawat has argued at length,
Yes.
and I have taken into consideration all these things as per section 5 or section 2 and 3. They can, but not the quasi judicial matter.
Not.
Yes.
Administrative matter they can, but the quasi judicial no. And I think-
Till examination they can, but thereafter they cannot.
and,
hearing they cannot.
and now this matter was brought to the notice of the ministry, and ministry has also taken into consideration that how this has been happened.
There has been a show cause also. There has been a
Ministry
show
has
cause.
taken a serious to it.
I'll try to take an instruction.
Okay, 89 days for delay condone, then we'll
55 days.
55 days. 89
Oh,
is
it's
mentioned.
very.
2 and 1 and 2 and so for the respondent number 3. Full stop. The appellant has filed the present appeal. Against the order dated 23rd of January 2023, passed by the hearing officer of trademark by refusing the trademark application number 1074212 in class 25 and allowing the opposition number 232471. 232471. The appellant has also filed an application being GA1 of 2023, saying for continuing the delay of 89 days for preparing appeal. Counsel for the respondent number 3 has raised objection and submitted the explanation. The explanation mentioned in the application is not sufficient to condone the delay of 89 days and prays for rejection of the application. At the learned counsel for the respective parties, the application and the grounds as mentioned in the application, this court find that sufficient cause has been shown for condoning the delay of 89 days in preferring an appeal against the order dated 23rd January 2020. Okay, accordingly, delay of 89 days is condoned. Full stop. GA 1 of 2023 is disposed. Appeal is admitted. Have you served the copy?
Yes. Absolutely.
Will you file affidavit now? I am fixing.
I may take an instruction. If it goes back, goes back.
No, full stop. Please the matter on. Appeal is admitted as all the parties. You are also received the copy. As all the parties have received the copy of the appeal. This is the matter on 6th of September 2020. Next.
Grateful.
Obligement.
Item number 9, my lord. I am for the appellant, my lord. On last occasion, this is my rectification application. My lord, on last
Respondent number 2, my lord, here.
The private respondent informed that they intend to withdraw this application, this trademark application, which I have sought for cancellation, my lord. Now, your lordship directed them to brought the same affidavits. My lord, they have
The
served me
affidavit is
copy, my
ready.
lord. Only one indulgence. If your lordship kindly allow my application recording that they have submitted that affidavit, that
Order remain.
my lord,
The order passed by the authority will remain.
Examiner order passed by examiner. Here also.
We have filed the withdrawal. We have also filed the letter praying that this particular withdrawal letter should be allowed, using my mark, abandoning my mark for this period of time.
So considering this, I am remanding to the authority.
nothing remains, my lord. If they are withdrawing that particular application, my lord.
They have to, my lord, surrender before the registrar also. Their
they-
trademark. It is valid for 30. 30. Presently, it is valid for 30.
Application क्यों दे दी? साला बट्टे।
I have already paid in my application.
Because they have filed an application before the registrar trademark.
Yes, my lord. Now, considering that, if your lordship kindly direct the
So that's why on the basis of this affidavit, I am setting aside this order.
Yes, my
I
lord.
am demanding sending the matter to the registrar to consider and pass appropriate order in terms of their application for withdrawal.
Yes, your lordship.
That will be better.
my lord.
Because
My lord, their trademark.
One humble
Yes,
submission that
their trademark is valid up to 2030, my lord. So they have to surrender it before
My
their
lord, if your lordship kindly, subject to correction, my lord, if your lordship kindly direct the register of trademarks, the recording this representation to remove the mark.
Correct.
My lord,
That's
my
right.
lord. That's
So on the basis of this affidavit, I am setting aside,
Yes, my
and they have filed an application before the registrar for
Yes,
withdrawal.
yes, my lord.
So I direct the registrar to consider and pass appropriate order of withdrawal of their mark
Based on their application, my lord.
within a specified time.
Yes, my lord.
Yes.
Grateful.
Correct. Time frame like that.
Where is the impugned order?
My lord, the impugned order. The difficulty all are.
There is a page number here, my lord.
My lord, page number 80, P7.
80.
Oh, my lord, this is the investigator's affidavit, my lord. No.
80.
My lord.
That is the affidavit. Affidavit.
Yes, that is the affidavit, man.
Last page, after the page number is over, last page, my lord.
That is under.
No, my lord, that's a legal certificate, my lord. That's a legal certificate.
That's
Lordship, kindly give me a moment, my lord. Let me.
These are the record. Where
These are the records, my lord. I believe impugned order is not.
Impugned order is not here.
Not here.
They have not annexed it, my lord, here in the appeal.
As per the index, there is no impugned order.
Yes.
These are all transferred matters, my lord. We don't have any.
That's why I am calling for, in all cases, I am calling for the record.
Yes, my lord.
Otherwise, it will be difficult.
April 13, 2010.
সেটা তো লেখা আছে।
These are all the pleading before the.
Yes, my lord.
Yes, yes.
Well, this is not an appeal. There should not be any impugned order. Well, this is my rectification application. So based on their trademark, since I found their the trademark which is completely identical with my mark, so I have sought for cancellation of their mark. There should not be any impugned order, my lord. That's why I have enclosed the legal certificate, which is at the last page, my lord. after page 84. Well, these are the legal certificates. but
Certificate.
that is not there. I'm only seeking cancellation of this particular trademark, which they have now.
Which trademark?
My lord, it's Polydor, PolYdur. My lord, lordship will get it after page 84. My lord, running page 85 and 86, although the page marking is not there. My lord, last page, my lord, last.
Only the undertaking is there.
My lord, I have my copy, my lord, I'm sorry. I don't know what has come from IPAV, my lord. It's very difficult. May I hand over my copy to your lordship? Your lordship will kindly say the last page.
After page 84, my lord, last page.
Certified copy of the registration. This is the only.
This is only, my lord.
Certified copy of
Yes,
the
my
registration
lord.
issued on the basis of the computer data on day to day. If any disturbance is
And
noted,
this mark only they have withdrawn. That is 1949642 in class 2, my lord.
where is the mark here?
My lord.
The mark is not reflecting here.
No, mark is reflecting, my lord. My lordship will kindly see. It's a word mark. That's why.
That's where.
Your lordship will kindly see, my lord, the second last word mark. My lord, restrictions on at the bottom portion. Thereafter, my lord, goods and descriptions. Thereafter, word mark. Trademark type, my lord, word.
Polydor.
My lord, last page of the compilation, my lord.
Manufacturer and merchant.
My lord,
In the last
from the
three lines,
bottom, my lord, last
the last-
line, my lord.
Yes, yes. Subject to the.
Yes, my lord, just one,
Polydor.
third and fourth line, my lord, from the bottom.
Powder paints and dry paints.
My lord, yes, that is the goods and description. Then word mark, Polydor, and then trademark type word mark.
So this is an application.
My lord, this is rectification application.
Application.
Rectification application.
Census appearing for the petition, census appearing for the respondent. Solution, the petition has filed present rectification application of the trademark application number 1949642, comma, trademark number application number so of the word mark Polydor, 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 trademark type word. The counsel for the respondent has filed an affidavit.
Respondent number 1, my lord. 1.
Respondent number 1. Mr. Mr. Debashri Mukherjee, son of Amit Mukherjee, comma, who is working for gain in the petitioner company Berger India Limited at Berger House 129, Park Street, Kolkata, has filed an affidavit stating as follows. Set out paragraph. On the basis of the affidavit filed by the respondent number 1, comma, the counsel for the respondent number 1 submitted that as the respondent number 1 company has already submitted a letter for withdrawal of submitted a letter for withdrawal of the registration number 1949642 in class 2, which is in the name of the respondent number 1 under the trademark Polido. Under the trademark Polido. Consider the submission made by this one before the Polido. Counsel for the appellant on the basis of the affidavit submitted by the respondent 1 submits that the impugned
আগে দুটো করে চলে গেছে কোথায় নিচে গেছে
committed that let the matter be remanded let the matter be remanded to the register trademark with the
register of trade
register of trademark Kolkata for taking appropriate steps in terms of the letter submitted by the respondent number 2 for withdrawal of the trademark, namely respondent number 1. Yeah, bola. Respondent number 2 is directed, the registered trademark is directed to respondent number 1 for withdrawal of the trademark Polido, being application number 1949642 in class 2. Class 2 within a period of 2 weeks. Yes, Mr. Singhania, 2 weeks.
Milord, there are only 2 registrars and 18,000 applications are there. So they are after your lordship passes the order, they are doing that only, Milord. So kindly give them some more time.
It's only withdrawal, my lord.
Because
Maybe, but they can withdraw. But
within a period of 3 weeks from the date of receipt of the order of this court.
let the affidavit be served upon me also, Milord, on the respondent 2.
I'll give them in court. I'll give them in court.
In view of the submission made by the counsel for the respondent number 1 and the affidavit submitted by the respondent number 1, IPDTM number 119 of 2023 is disposed of.
Grateful, my lord. Much. My lord, may I take back my copy, my lord?
Yes.
Grateful, man.
Next.
Grateful. This is appearing at my instance, my lord. My lord, I was praying for directions for discovery and inspection, my lord. I had filed an application for additional documents. The honorable judge has been pleased to allow the application, but the order is still not. We have mentioned thrice, my lord.
So what can be done?
Well, with regards to document, it was pronounced in open court, my lord. Lordship can issue the direction.
It has not come out, so it was pronounced in the open court. So
I don't think, well, there's any impediment in
it
the.
was also mentioned. There is no impediment, but I am not sure whether this will create any additional problems or not.
What is the stage of the suit here?
Discovery inspection.
Discovery.
To complete it.
I'll complete that.
And no, I don't have any problem. If the order comes out, then we have to again go for another set of discoveries.
No, because the order was pronounced. Now it's known that the application has been allowed. Just that it's not been uploaded.
Yes, it was passed on 14th.
Unless it is signed. So and so appearing for the plaintiff, so and so appearing for the defendant. It is fine from the record. The case is at the stage of discovery and inspection of the documents. Accordingly, the parties are directed to complete the discovery and inspection of the document within 3 weeks.
Lordship.
Full stop. Affidavit of admission and denial of the document be filed within 2 weeks thereafter. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. This is the matter on 3 weeks, 2 weeks, 5 weeks. No? This is the matter on
after the action.
27th of September 2024 for framing of issues.
Lordship.
By time you will get the order.
We hope so.
Yes, next.
Okay.
For the plaintiff, my lord.
Yes.
Today this matter is
for the defendant.
my lord, for extension of mandate of the court-appointed commissioner for
20th August.
20th August, my lord, was
What is the stage?
my lord, evidence in chief is almost complete.
Still, chief is going on.
Chief is going on, my lords, because there's voluminous document, set of documents. So chief will be completed very shortly. Then my learned friends will cross-examine the witness. Only one witness is there, my lord.
Their witness, the
My
defendant
lord.
will not add his evidence.
My lord,
My
it's
lord,
undefended.
it's undefended. So the
Undefended.
defendant of file written statement, my lord.
4 weeks later. Month of September.
Have you cross-examining?
Not yet, my lord.
Consistent appearing for the plaintiff, consistent appearing for the defendant. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff for extension of time to file report by the commissioner. This court, by an order dated 11th June 2024, has appointed the commissioner for examination of the plaintiff's witness on commission. It is submitted that examination in chief of the plaintiff witness is going on and prayed for further extension of time so as to enable the commissioner to complete the examination of the plaintiff's witness on commission. In view of the submission made by the counsel for the plaintiff, time to file report by the commissioner is extended. 4 weeks.
4 weeks will do, my lord. 4 weeks will be
For a
sufficient.
further period of 4 weeks. Police commissioner is directed to submit the report by 30th September 2024.
Deeply obliged.
Item number 12.
Next.
My lord, item numbers 12, 13 and 14, my lord, those 3 suits, my lord, in which, my lord, on the last occasion, my lord had asked me to obtain the certificates from the department regards the non-appearance of the defendant, my lord, I have obtained that.
After the publication?
Yes, my lord, after the publication, my lord, it is dated yesterday. My lord, until 2:30 p.m. yesterday, my lord, there was no intimation regards the defendant's appearance, my lord.
All defendants?
Yes, my lord, all the defendants. There's a single defendant, my lord.
Defendant.
Yes, my lord. In all the 3 suits, there's a single defendant.
So and so appearing for the plaintiff. None appears on plaintiff fully. So the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff submits that initially, the plaintiff has taken appropriate steps for issuance of writ of summons upon the defendant, and accordingly the same was issued, but could not be served upon the defendant and written unserved. Full stop. Thereafter, the plaintiff, as per the leave granted by this court, has published their notice of the suit and notice of the case in the paper publication, and the paper publication is filed before this court by way of affidavit of service. In spite of paper publication, today, counsel for the plaintiff has handed over the 3 original the report issued by the Deputy Registrar within bracket legal dated 12th August 2024, wherein it reveals that the defendant has not appeared either in person or through advocate till 12th of August 2024. Let the report submitted by the report issued by the Deputy Registrar Legal be kept in the record. In view of the above, CS number 77 of 2022 be placed in the list of undefended suit. Full stop. The plaintiff is directed to file judge's brief of document within 2 weeks.
My lord, 3 weeks would do, my lord.
3 weeks. Full stop. The plaintiff is also directed to file the affidavit of evidence of the plaintiff witness within a week thereafter. Full stop. List the matter on. How many witnesses you are having?
My lord, would be 1 witness, my lord.
List the matter on. Give the date. You will bring the witness?
Yes, my lord, we'll bring the witness, my lord.
27 September. 27 September, 3 p.m.
I'm extremely grateful, my lord.
All 3 matters?
Yes, my lord, all 3 matters.
Separate order.
I'm extremely grateful, my lord.
Next.
Court orders, item number 15.
I'm for the respondent. I'm for the plaintiff.
the defendants number 1 and 1 to 5 are restrained from operating the bank account of so and so by keeping aside the amount of rupees 6 crore so till 17th of September. As regard GA2 is dismissed.
Grateful, my lord.
Especially mixed matters, item number 17.
I appeared for the defendant number 1.
Well, Lord, if your lordship recalls the same matter where well, I was appearing for the defendant number 6 and 7, I had concluded. Sets were replying, well, I said that it does not apply to me because the contract is not with me, no privity and all
6
that.
and 7.
Yes, my lord. I am in a different footing because my lord, the
You are for
contract
the-
shows that for defendant number 1. Now the contract would show that the contract was entered between the plaintiff and the defendant number 1. Now, if your lordship kindly takes volume 2 once.
You are for the only defendant number 1.
I am for 1, 2, 3, and 5.
1 to 5.
Because the contract was only with defendant number 1.
Correct.
And so if your lordship kindly takes page 138 at volume 2.
138.
Yes.
Yes.
This is the contract, my lord. There are several contracts. I'll show one by one. At page 144 is the dispute resolution procedure.
Yes.
Any dispute, controversy, or claim arising of or relating to this contract, including its conclusion, interpretation, performance, breach, termination, or invalidity, shall be finally settled under the rules of ICC Italy by Chamber of Commerce and Industry in Rome, appointed in accordance with the said rules. The place of arbitration shall be Rome. The language of arbitration shall be English. If your lordship kindly note the pages, my lord, each and every contract contains the same clause, similar clause.
You referred 138.
138, then at 144, thereafter 156, the dispute resolution procedure is at page 161.
All are same.
All are same.
Okay.
So, my lord, we have filed a section 45 application. On the last day, my lord, the direction was made, affidavits, and it is returnable on the September 20. September 20 return. Now, my lord, I say that if this honorable court decides that this court will not have jurisdiction because of this arbitration clause, interim orders also cannot be passed. Because, my lord, if there is a question, if there is an issue of jurisdiction which has been raised by any of the parties, that issue has to be addressed first. Therefore, my lord, I am praying that this interim order at this stage be vacated. My lord, we could not file an affidavit in this because, my lord, lordship, no section 45 has to be filed first. So, my lord, I'm also asking that in this application, it be pending and direction of affidavit be given to us. We will file affidavits. Let our section 45 be heard first.
23rd of August.
20th of September it is returnable. After the affidavits. Your lordship passed in direction on the last occasion for affidavits and returnable on 20th of September. Therefore, my lord, at direction of affidavits in this application also be given. We will file our affidavits now because now we can file because section 45 has already been filed. And thereafter, my lordship will first adjudicate the jurisdiction point. And then if your lordship thinks that no, this court can adjudicate the issue raised here arising out of the contract which contains the arbitration clause, then we will argue on this.
Yes. So what about the other defendant? Why the other defendant should suffer?
Well, I will suffer the interim order till the 20th of September.
They stand in a different footing. They have made their argument.
Yeah.
Correct.
Here, I'm for the defendant number 10. Interim award, if it is vacated.
It can be, of course, I will say that it will be vacated.
Which your lordship has passed.
Let it be vacated.
No, because my learned friend's defendant number 1 submission, if I have understood him correctly, the jurisdiction has to be decided first. So if the jurisdiction is decided, then there's already an order for exchange of affidavits. So on the returnable date, at best, at the earliest, it can be decided, not before that. They must have the opportunity to use an affidavit. So in the interregnum, the consequence would be the interim order to continue till the 20th. So we've been heard extensively on our point
Correct.
So I was respectfully submitting.
That's why on your behalf, this court has argued.
Absolutely. I'm grateful, my lord. So kindly decide this point, and then 45 will take its own course. So even if 45 is allowed, the subject matter of the suit will get referred to arbitration.
Yes, but my lord, if 45 is allowed, then my lord, this court will not have jurisdiction to pass the
That's
interim order
correct.
also.
That's correct. Now the problem is that the defendant number 6 and defendant number 10, 6 and 7 and defendant number 10 are telling that they are in the different footing, and you are also admitting that they are on the different footing, and they already argued the matter. Correct. The the interim application cannot be taken of a hearing for the 6 and 7. Today I have passed an order for 10. Tomorrow I pass an order for 1. I will pass an order.
I am also praying for vacating this order. I'm not praying for vacating this order. I'm praying for vacating because of the reason, my lord, that the jurisdiction has to be first adjudicated. Before that, ad interim.
With regard to the interim order, your main
Ad interim order,
ad interim order, with your contention is that as per the clause 13, this court is
all
not
the
having
clauses
this
in the
jurisdiction.
different, but they're different.
Whatever it
Yes.
may be, this court is not having jurisdiction, so this
pass
court
even the ad
cannot
interim.
pass that. That is the
yes.
Yes. Now I take from the petitioner.
While reading the brief, my lord, reading the brief reminded me, my lord, of those time when, my lord, the courts started granting, or my lord started saying that don't grant injunction in bank guarantee and letter of credit matters because that affects the business and foreign trade. Foreign trade particularly, don't allow impression to be created that, my lord, India, my lord, is not a safe place to trade. Now, my lord, here, my lord, it's the reverse situation. That unless injunction is there, the foreign traders would, my lord, get the impression that it's not a safe place to trade. I will tell your lordship why. My lord, lordship is aware of the facts. Your lordship had, my lord, while passing the interim order, had, my lord, I will place the facts to the extent required, but not in its entirety. Definitely, my lord, the plaint consisting of, my lord, about, yes, number of pages. Now, my lord, what is the case of the plaintiff? The case of the plaintiff is, my lord, that the plaintiff wanted to procure some, my lord, ferromanganese, I say, goods of different types. Ferromanganese, silica manganese, etc. My lord, I do not want to, my lord, trouble your lordship with all these particulars. So, my lord, the plaintiff made, my lord, there is a website there, my lord, the plaintiff made a trade inquiry. It was responded by or on behalf of, my lord, the first defendant. They responded. The first defendant responded. My lord, a contract was entered into. I will tell you, lordship, there were in all 8 contracts. Now I am addressing your lordship on the first contract. The first contract was entered into. It was for a small quantity. Value was small. It was, my lord, just, my lord, prior to the COVID. The contract term was that, my lord, 10% advance and, my lord, the balance, my lord, on shipment. COVID intervened. The defendant number 1 said, sorry, I cannot dispatch unless you pay. So, my lord, good faith, payment was made. The dispatch came. In the interregnum, my lord, the plaintiff was informed that, my lord, the defendant number 1 was procuring the materials from, my lord, defendants number 6 and 10 who are really opposing today. Your lordship has seen. 6 and 10, my lord, are two group companies. That is my case, my lord, as on date, whatever my client has said, there is no opposition, though, my lord, more than or possibly 3 months have expired, my lord, after the ad interim order was passed. That was passed in May. Till date, my lord, no affidavit has been filed, no application has been filed. Now, what he says is, on oath, that, my lord, the defendant number 1 informed that he was procuring it from 6 and 10. My client approached 6 and 10. They admitted that yes, we are supplying, but we can also supply to you at a higher price. Not at the price at which the defendant number 1 is supplying to you. Now, my client, my lord, according to me, ought to have been cautious at that point of time. Because, my lord, the defendant number 1 is procuring from 6 and 10 at a price and supplying to me. Must be he is having his margin there. But the defendant number 6 and 10, when they want to supply me, they say that they would be supplying at a higher price. Why? They say we have some understanding with the defendant number 1. We shall supply the defendant number 1 at a lower price. So, we had to, if we had to procure the materials, we had to do it through the defendant number 1. Then comes the second contract.
So how the defendant number 6 and 7?
I shall come to that. Till now, my lord, there is no difficulty. 6 and 10 has no role to play. Second contract. Again, my lord, the same terms, 10% and balance. No, please pay me beforehand. Even though the contract was 10% and balance on shipment, it was modified. Entire payment was made. Dispatchment. Third, fourth contract, my lord. Part dispatch is paid. There, my lord, the role of, my lord, that is the pleading, the defendants number 6 and 10 comes in. They say that you make the payment and then we shall supply. That is where, my lord, the role of defendants number 6 and 10 comes in.
But where is the direct connection with you and the defendant number 6, 7 and 10?
They induced me, my lord, 6 and 10 induced me to make the payment. Had they not induced me to make the payment, I would not have paid. This, my lord, the statement which has been made remains uncontroverted till today. My lord, the first thing, my lord, I expected was a small affidavit that before going into the details, we file an affidavit saying that we had no role to play. I have named the persons who made the representations on behalf of the defendants number 6 and 10. And I have said that this persons represented 6 and 10 in inducing me to make the payment.
Yes.
If they did not have done that, if they had not done that, my lord, I would not have any cause of action against 6 and 10 and its officers. Kindly appreciate a situation. I know, my lord, 6 and 10 are supplying to 1. I approach. I had a talk with them. I shall come to the, my lord, inspection, etc. Because at my instance, inspection was taken, my lord, at the factory of 6 and 10. 6 and 10 would not have allowed inspection by my agent had they not known that, my lord, I was, my lord, the actual buyer. Be that as it may, I would not have, and my lord, the rest of the contracts, 3 onwards, my lord, the contract values are much more than 1 and 2. So, my lord, I was induced to pay by 6 and 10 that you make the payment, we shall supply. You make the payment, we shall allow the goods to be loaded in the container.
To whom you have paid the amount?
I have paid to defendant number 1. My case is, my lord, the defendant number 1 has in turn paid to the defendants number 6 and 7. Even if I make the payment to, my lord, defendant number 1, on being induced by the defendants number 6 and 7, kindly appreciate my difficulty.
Yes.
Kindly appreciate my difficulty. Had they not said this, that you make the payment to 1 and then we shall supply, my lord, my client would not have made the payment.
How you can prove that yes, this is the induced by the defendant 1/6?
Firstly, my lord, I do not want to, my lord, say that here right now because I would, my lord, like to reserve that, my lord, for my affidavit in reply. They would be cautious in their affidavit in opposition. But, my lord, two things. I have said on affidavit that, my lord, I was induced by defendant number 6 and 10 and the persons in control of 6 and 10 to make the payment. And on the basis of that, my lord, I made payment to the defendant number 1 and the defendant number 1 in turn had paid to the defendant number 6 and 10. There is no affidavit in opposition. Now, when the affidavit in opposition comes, my lord, two things, my lord. It's an oral agreement. I can prove, my lord, by adducing evidence and, my lord, whatever the other evidence we have by producing that. 3 months, my lord, was it not sufficient for them to come up with an affidavit saying that, look here, all these statements made against the persons in control of 6 and 10 are false?
If they are not choose to file the affidavit,
Yes.
that is the matter. Without
Yes.
the affidavit,
Yes.
that is to be on record.
The consequences, my lord, because, my lord, in that event, my statement as on date remains uncontroverted.
Yes.
Now, my lord, factually, no, Dakabo.
Yes.
Now, my lord, this is why, my lord, I say that I have a cause of action against the defendants number 6 and 10. Now, my lord, forgetting about affidavit, my lord, there is no application under Order 7, Rule 11.
Nothing.
Saying that the plaintiff does not disclose any cause of action. My lord, Lordship is aware, my lord, I do not want to cite those cases now that even, my lord, vague allegations, my lord, on the saying that there are vague allegations in the plaint, my lord, a plaint cannot be rejected under Order 7, Rule 11. That has to be tried. Now, my lord, kindly come to some paragraphs of the plaint, my lord. Plaint is volume 4, yes. সেটা তো দেয়নি বোধহয়। না, না। এগুলো প্লেন্টেড প্যারাগ্রাফ তো
পিটিশন প্রথম দিকে একই প্যারাগ্রাফ
হুম
পিটিশন প্রথম দিকে চেঞ্জ
13 থেকে
আছে প্যারাগ্রাফ 5 থেকে আছে
ঠিক আছে Lord, kindly come to paragraph
5 থেকে শুরু এমনি আদারওয়াইজ
starts from paragraph 5 basically, but kindly come to paragraph 13.
Yes.
Sometimes in the first week of June 2020, the plaintiff entered into discussions with the defendant number 6 for purchase of bulk quantities of 1000 metric ton and above of such and such through a common acquaintance so and so. The plaintiff was informed by the person that the defendant number 6 had quoted a price of around $900 for supply of bulk quantity of this ferromanganese. The plaintiff was surprised to receive this offer as the defendant number 1 was supplying a lesser quantity of the same product manufactured by the defendant number 6 at a price of 795.78 euro, approximately 875 USD, under the first contract. The price of high carbon manganese is substantially discounted when purchased in bulk quantities. Further, the market price of the product had also fallen and was in the range of such and such. In these circumstances, the plaintiff informed Mr. Batra that the price quoted by the defendant number 6 was unrealistic and that it was expecting a price in the range of 600 euro. It transpired that Mr. Batra informed the counteroffer of the plaintiff to the defendant number 6, who represented by an email of 8 June 2020 to Mr. Batra, stating that it would rework its offer. Mr. Batra replied to the defendant number 6 by his email of 9 June 2020, which was also copied to the plaintiff, providing the clarification sought by the defendant number 6 and requested for a virtual meeting between the plaintiff and the defendant number 6 on such and such. A virtual meeting on this Skype platform was held on 10th June 2020 between the plaintiff's director.
আছে পেজ 149 এই ইমেলটা যেটা মার্ক টু বোথ ডিফেন্ডেন্ট নাম্বার 3 এন্ড মি annexure J.
My lord, before going to paragraph 16, my lord, kindly come to annexure J at page.
তার আগে আইও আছে আইটা দেখে 149 150
Kindly come to volume 2, yes. Kindly come to volume 2. Kindly come to volume 2, my lord. Kindly come to first page 149.
Yes.
Kindly see, my lord, the mail is, my lord, from export sales shamgroup.com. That's, my lord, 6 and 10. I say that, my lord, it belongs to the same group. To Pratik Batra. Dear sir, now kindly come to the second paragraph. With reference to your email, I am really glad the buyer is ready to take this forward, and I thank you for all the extended support in doing so. Page 140.
Yes, yes. But who is export sale?
Sorry, my lord.
Who is export sale?
The export sale is, my lord, Sham Group at the rate at, my lord, kindly see.
At the rate Sham Group.
Yes.
Number 6
6 and 10, my lord, copy to kindly come to, my lord. It is addressed to Pratik Batra. Then kindly come to CC, Sanjoy Sham Group, MNL Sham Group, subject high carbon ferromanganese. Then kindly come to, my lord, the last 3 paragraphs. It will be very helpful for us if you can once kindly check from them at what level 30% reduction, to be honest, is surely not possible. And terms CIA for FQB They are firm in buying target price and quantity and let us know. So accordingly, we can rework entire thing and get back to you soonest. And please check if they are asking the quotes in Euro or USD. Then kindly turn the page. This is the reply of my Lord Pratik Batra.
Yes.
From Pratik to export sales, Sham Group, copy to so and kindly see the last copy, info@dvx.com, page 150. That's my Lord the plaintiff.
Yes.
So my Lord Pratik writes to Sham Group with copy to me. Hi, Mr. So-and-so, Euro and USD are primary currencies we are dealing with. However, Euro for all our future communication is preferred since we deal primarily with European market unless otherwise, if ever, I will inform you accordingly. Quantities remain as stated before with sole perspective of increasing than latter, but the target prices for the compositions remains as stated. Accordingly, you can revise and reshare the codes. Moreover, I would also like to use the opportunity to schedule an introductory Skype call tomorrow with Mr. So-and-so, reading in CC, buying party from Italy. Joining us currently from France due to the lockdown. Please let me know if it is convenient for you to join us at so-and-so on Skype tomorrow on 10th June or another time that is okay. Now let's kindly come back to the plaint. Paragraph 16. পিটিশনটা দেখে দেখানো বোধহয় সুবিধে হতো বলছি পিটিশন থেকে একই আছে
পিটিশন আমি মার্ক করা আছে
সেই
এন গুলো হলুদ আর সিক্স গুলো সব
Well, let's kindly come to paragraph 16. A virtual meeting on the Skype platform was held on 10th June 2020 between the plaintiff's director, Mr. So-and-so, Mr. Shayan Chatterjee, Senior Manager, Sales and Marketing of the defendant number 6, and Pratik Batra. In course of such meeting, it was represented by Mr. Shayan Chatterjee that the defendant number 6 was a part of the Sham group of companies, which included the defendant number 10 and Sham Metallics and Energy Limited. Mr. Shayan Chatterjee claimed that defendant number 6 and 10 could single-handedly meet the plaintiff's requirement of all kind of ferroalloys. The parties discussed about the procurement of bulk quantity of diverse ferroalloy over a long term. In course of negotiations, the defendant number 6 stated that it was aware that the plaintiff had bought a consignment of 216 MT of high carbon ferromanganese manufactured by the defendant number 6 through the defendant number 1 at a price of such and such. However, the defendant number 6 declined to disclose the price at which the defendant number 1 was purchasing the material from the defendant number 6. The defendant number 6 also declined to reduce its offered price below $800 per metric ton for sale of bulk quantity directly to the plaintiff. However, the defendant number 6 confirmed and assured the plaintiff that the defendant number 1 was associated with the defendant number 6 and 10, and the said defendants would perform and deliver all orders placed by the plaintiff on the defendant number 1, provided they received full payment before loading of containers. The defendant number 6 further represented that as a special case, the defendant number 6 had commenced loading containers arranged by the plaintiff before receipt of full payment from the defendant number 1, only on the request of the defendant number 1 to give delivery of the goods, as the plaintiff was a potential major client. However, in future, cargo would be loaded in the containers only against receipt of full payment. The defendant number 6 stated that it could not offer the discounted rate to the plaintiff, which it offered to the defendant number 1 because of its long-term association with the defendant number 1. In these circumstances, the negotiations with the defendant number 6 did not fructify, except for assurances and promise by the defendant number 6 that all contracts placed by the plaintiff on the defendant number 1 for goods to be supplied by the defendant number 6 and 10 would be duly performed. Such assurances were made by such and such. Then kindly come to paragraph 18. Solely relying on the assurance and promises made by the defendant number 6 in course of virtual meeting held on 10 June 2021, the plaintiff authorized its bank to remit the entire balance consideration of such and such euro in 3 tranches of 25,000 euro and 25,000 euro and 55,000 euro on 11 June 2020. Copies of the bank receipts for remittance are, my lord, those are at page 151 onwards. Now, my lord, kindly come to the next page, my lord.
So this all amounts has been gone to defendant number 1.
One. The amounts, my lord, there is no, my lord, dispute that the amounts have gone to the defendant number 1 from my account. I am not saying, my lord, for a moment, I am not saying that, my lord, any amount has gone from me to the defendants number 6 and 6 or 10 or to anybody else. Now, kindly come to, my lord, paragraph 20. The defendants number 1 and 6 had gained the trust and confidence of the plaintiff by delivering the consignment of high carbon ferromanganese under the first contract. The defendant number 1 represented to the plaintiff that it could deliver further quantities of the same commodity sourced from the defendant number 6 at a price lower than the price of the first contract if the plaintiff increased the quantity.
Yes.
Pursuant to negotiations, the plaintiff and the defendant number 1 entered into a sales and purchase contract bearing number such and such dated 14 July 2020, by and under which the defendant number 1 agreed to sell and deliver to the plaintiff 540 metric ton of this ferromanganese at 700 euro per metric ton. So at a reduced. Then, my lord, kindly come to paragraph 22, my lord. I have made spoken about the payments made. Then kindly come to 23. The plaintiff was not obliged to make any further payment till it received delivery of the materials. However, sometimes in the 3rd week of August 2020, the defendant number 3 representing the defendant number 1 claimed that the defendant number 1 had already made payment of about rupees 72 lakhs to the defendant number 6 on 30th July 2020 as advance for purchasing goods which the defendant number 1 would supply to the plaintiff. The defendant number 1 represented that it was in urgent need of funds and was also required to make further payment to the defendant number 6 in order to comply delivery of the contracted cargo. In course of discussion with the defendant number 6, the said defendant had assured and promised the plaintiff that it would duly supply materials to the defendant number 1 for onward supply to the plaintiff, provided it received full payment for the same from the defendant number 1 before loading of containers. It transpires that the defendant number 6 had informed the defendant number 1 of his discussion with the plaintiff, and the defendant number 3 was aware of such discussion. Relying upon the aforesaid assurances and promises given by the defendant number 6 to the plaintiff and not otherwise, the plaintiff issued a payment instruction of such and such euro with its bank on 25th August. Then, my lord, kindly come to next paragraph. Sometimes in the 1st week of October 2020, the defendant number 1 represented to the plaintiff that a substantial quantity of the contracted cargo had been manufactured by the defendant number 6, and the defendant number 6 was ready and willing to commence supply in parts provided it received the entire balance payment. As it was represented to the plaintiff that the defendant number 6 would duly deliver the contracted cargo the plaintiff issued payment instruction for the entire balance consideration of 273,000 euro in 2 installments of such and such, and the last installment of such and such. In this regard, copies of the bank receipts, my lord, I am not showing those. Then 26. The plaintiff was informed by the defendant number 1 that it had completed payment of the balance consideration payable by it to the defendant number 6 on 15th October 2020, and the defendant number 6 would shortly load cargo in the container arranged by the plaintiff. The entire cargo under the contract was duly delivered by the defendant number 1 and 6 to the plaintiff on or about 14th October and 25th October. 20 number of containers were shipped under 3 several bills of lading. So, my lord, there is no dispute. Entire. Then kindly come to, my lord, the next paragraph 27. The defendant number 1 represented that it could supply superior quality of the ferrosilicon manganese manufactured by defendant number 6 at competitive rate. The plaintiff required this product in the usual course of its business and entered into negotiation with the defendant number 1 for purchase of 3,000 metric ton of product manufactured by the defendant number 6. However, subsequently, the defendant number 1 stated that it would source 1,500 metric ton of the contracted goods each from the defendant number 6 and the defendant number 8. The defendant number 1 represented that the defendant number 8, like the defendant number 6, was a reputed and well-established manufacturing company, and the defendant number 1 was associated with the defendant number 8 on similar terms as it was associated with the defendant number 6. The defendant number 1's representation about its association with the defendant number 6 had been confirmed by the defendant number 6, and the previous contract had been duly performed by the defendant number 1 and the defendant number 6. In these circumstances, the plaintiff had no reason to disbelieve the representations of the defendant number 1 of its association with the defendant number 8. Now, my lord, kindly come to next, my lord, the contract was entered into. Then paragraph 30. Subsequently, the defendant number 1 represented that it was able to give immediate delivery of 1,000 metric ton of the said goods, sourced in part from the defendant number 6 and 8, and requested the plaintiff to make advance payment of the price of 1,000 metric ton of the 1,000 metric ton and arranged containers. Relying on the representations, my lord, these payments were made. Then, my lord, kindly come to page 22, just above, my lord. Sorry. Just above, my lord, paragraph 32. I'm sorry, my lord, I was reading for the petition. Just above paragraph 32, upon receipt of the aforesaid payments, the defendant number 1 informed the plaintiff that it had made payment to the defendant number 6 and requested the plaintiff to arrange pre-loading inspection of the goods at the factory premises of the defendants number 6 and 8. The plaintiff arranged 37 numbers of empty 20-feet containers from so-and-so through its broker. On the instruction of the plaintiff, Lancer Container Lines issued the container release orders dated such and such. The defendant number 1 collected the container release order from the office of such and such. Then, my lord, kindly come to '33, '34, my lord, the deliveries. No, 34, kindly come to. 34. Kindly come to 34. After taking delivery of the 37 numbers of empty containers, the defendant number 1 informed the plaintiff that the plaintiff could take pre-loading inspection of the goods at the factory premises of the defendant number 8 on 15th October 2020. Accordingly, the plaintiff instructed SGS India Private Limited to carry out the following: draw samples in the course of packing of cargo, seal the loaded bags, carry out chemical analysis, attend loading operation, seal the stuffed containers. Then, my lord, kindly come to Yes. Kindly come to my lord, paragraph 39, my lord.
Yes.
The plaintiff was informed by the defendant number 1 and 6 that 270 metric ton of contracted cargo were ready for delivery at the factory premises of the defendant number 6 at Raniganj. Accordingly, the plaintiff instructed SGS to carry out inspection of the goods and packing materials. Between 10th December 2020 and 12th December 2020, SGS attended packing of 270 metric tons of packing of 270 metric tons in the plaintiff's jumbo bags. In this regard, a copy of the email dated 14th December 2020 issued by SGS is annexed. Now, my lord, comments were made on this document. My lord, kindly once come to page 193. It's in the second volume, my lord, sorry.
Yes.
Annexure JJ.
Yes. Yes.
Now, my lord, this is from SGS to me. Dated, my lord, 14th December 2020.
Yes.
Dear sir, as per confirmation received from your supplier, we had deputed our representative at your supplier's nominated plant on, and the regular job update is as below. Job details, JF number 2034117, lot 2, 270 metric ton, sampling, etc. Now kindly turn the page. The inspection certificate.
Yes.
$194, sir.
Yes.
এগুলো তোরাই দেখিয়েছিস? Page 194, my lord. My lord, comment was made that, my lord, it has got nothing to do with the defendant number 6. There is nothing to show. Now, kindly come to the inspection certificate dated 25th February 2021.
Yes.
My lord, kindly come to the place and date of attendance.
Raniganj.
Yes, I'm obliged. Though, my lord, it was submitted before your lordship that from these documents it would not appear that the defendant number 6 had anything to do with this. It was never said that, my lord, defendant number 6 has its factory at Raniganj.
No, Mitro, it's correct. Admittedly, contact between you and the defendant number 1.
Yes. Yes.
And defendant number 1 has to procure the materials
Yes.
supplied to you.
Yes.
And admittedly, you have made the payment to the defendant number 1.
Yes.
Though defendant number 1 has arranged the materials from defendant number 6, 10, or 8, and wherever the factories it has been inspected or they have handed over to you, have taken, carry out the materials from them. So how you can connect with the liability of the defendant?
Connecting the first thing, my lord, I am showing this document.
Liability with regard to the interim order, what? With regard to the merit, that is subject matter. Now with regard to the interim order, the payment, because the payment schedule is with the defendant number 1.
Yes.
If the material has not been given, and defendant number 1, as per the discussion with the defendant number 1 or defendant 6, defendant number 6 has not given the material to defendant number 1, that is between them. Now you are claiming with regard to the amount.
Yes.
Amount is
amount and, my lord, the goods which are lying,
good
my
is
lord.
not there, and
The goods which are lying, my lord, in the, yes.
which is lying, that is to be, and the amount is to be secured with regard to that.
Yes.
The foreign company and all this thing, whatever. So how you can connect for the interim measure?
Yes.
The defendant number 2 to 6 to 10 are liable to pay the amount 6, 7, and 10.
Yes. Now, my lord, first I showed your lordship the mails, where, my lord, the knowledge of the defendant number 6 about my involvement would appear. There, my lord, the liability did not come in. My lord, what is my case, my lord? As I said, my case is that my contract with the defendant number 1 was 10% advance and balance on shipment.
Okay.
No, it is at the instance of the defendant number 6 and 10 that such contract was modified, or, my lord, the contract was not really, my lord, modified in writing, but I made payment of more than 10% to the defendant number 1 at the instance of the defendant number 6 and 10. Now, had they not made this representation, my lord, I would not have made the payment.
Where is the representation?
Yes, yes.
Where is the that's why I'm asking, where is the document or the things to say, yes, they have directed you to pay that amount, then we'll release.
My lord, it's oral. It's oral. Now, my lord, there can be oral contract, my lord.
Correct,
There
no
is no
problem.
difficulty.
There is no difficulty.
There is no difficulty. I say it's oral. Now, my lord, kindly, my lord, take a holistic picture of the entire transactions. First, as I say, that I enter into the first contract at a price. I come to know that defendant number 6 and 10 or 6, my lord, they are supplying to the defendant number 1. At that stage, it was 6. They are supplying to the defendant number 1 the goods at a lower price. At a price which the defendant number 6 did not agree to supply me directly. My lord, the trap was laid in this manner that, well, you go to defendant number 1, I will give you at a lesser price. Why? The defendant number 1, my lord, is kept in the middle, so you can't touch me for non-supply or for receipt of money. Defendant number 1 has no fund. That is why, my lord, the game plan is made in this manner that we shall supply to the defendant number 1 at a price at which I will not supply you. So I had to go to the defendant number 1. That is first. Next comes, my lord, the second stage. Defendant number 1 says yes, 10%. Balance on loading. Then they say that, look here, the defendant number 6 and 10 are saying that unless you pay, unless they are paid, they will not supply. The defendant number 6 and 10 also says that yes, you make the payment.
Right.
Had the defendant number 6 and 10 not said that, I would not have paid them the, my lord, paid the defendant number 1 the entire money.
But it is not your case. Okay, defendant number 6 said are reduced to pay the amount.
Yes.
You have not paid the amount to the defendant number 6 or
No, I have not. I had no privity with the defendant number 6.
There is no privity.
No.
So if it is so, how far you can bind them?
My lord, that is why, my lord, I said that, my lord, the fraud was perpetrated by them. My lord, kindly appreciate my position, my lord. My lord, I go to, my lord, procure something from, my lord, X. X says I am procuring it from Y. Very well. Now, Y says that you pay the entire thing to X, then I shall supply. Now, first, that is why, my lord, I said the first 2 contracts, my lord, there was no difficulty. They made the representation, the delivery came.
Yes.
My lord, I have, my lord, said that, I had placed that also before your lordship.
Because if, okay, defendant number one was not able to pay or supply, told her, yes, go, the material is available with the defendant number 6 or 8 or 10, whatever it may be, and take it and pay the amount. If you paid the amount to the defendant number 6, but the defendant number 6 has not given, that is different aspects. But what the conversation between the defendant number 1 and the defendant number 6, but all the transaction has been made by you with the defendant number 1. Can at the prima facie can the court say now the defendant number 6 also liable for that?
But I would say
Prima facie, I'm telling. With regard to the merit, that is different. thing, that is the
defendant number.
trial.
Sorry, my lord, I did not get your lordship.
With regard to the prima facie, with
Yes.
regard to the other matter, that is the trial. You can produce the witness, say whatever that trial will be. At the interim stage, you have to satisfy the court with regard to the prima facie.
Absolutely.
Prima facie,
Absolutely.
you have made out the case with regard to the induced, due to the inducement, you have paid the amount to the defendant number 1. If that inducement, how it prove? Only with regard to the inspection and the you have taken the material from the godown or from the
No. Neither inspection, not taking it, my lord, from the godown, my lord. I'm sorry. I possibly could not make myself clear. I can take inspection to, my lord, defendant number 6 as well.
That's why inspection of the defendant number 6 premature.
I can take inspection from the defendant number 6, my lord. There is no difficulty.
Correct.
Question is, my lord, whether the defendant number 6 knew about my existence, number 1. And number 2, my lord, whether the defendant number 6 and 10, I'm restricting it to 6, my lord, it applies to others also. Whether the defendant number 6 made the representation or induced me to make the payment.
That is the thing.
That is, my lord, if they had induced the averment in my petition, my lord, which remains uncontroverted, as
That's
on
a
date,
different thing. That is different thing. They have not taken out.
they have not. Now, my lord, if they deny, I shall, my lord, naturally I shall come up with the affidavit in reply.
Yes.
Now, today, my lord, I have said that they have induced me to make these payments.
Yes.
And that is my averment. I'll show your lordship the rest of the averments also if required. Now, that is my averment. They have received the benefits also. That is my further averment. They have received the benefits of the payments made by me.
Yes.
The money trail, I have said that, my lord, money goes from me to defendant number 1 and then to the defendant number 6 and 10.
Okay.
একেবারে ওখানেই চলে যাই।
Yes. Then,
my lord, kindly come to directly, my lord. I do not want to, my lord. Kindly come to paragraph. Kindly give me a minute, sir. Kindly come to, my lord, paragraph 104. Paragraph.
yes.
The defendants number, lordship got that?
Yes.
The defendants number 1 to 5 and the defendants number 6 to 10 and 13 and 14 have perpetrated fraud on the plaintiff in relation to the third contract, particulars whereof are as follows. The defendants number 1 to 5 and the defendants number 6, 7, and 10 fraudulently induce the plaintiff to enter into the third contract. The defendants number 1 to 5 and the defendants number 6, 7, and 10 made fraudulent representation to the plaintiff that they would sell and deliver 3,000 metric ton of ferrosilicon manganese to the plaintiff if the plaintiff made payment of substantial portion of the consideration in advance, knowing fully well that they did not intend to give delivery of the goods to the plaintiff. Then these defendants fraudulently deceived and induced the plaintiff into making payment of an aggregate amount of 585,000 euro as part consideration without having any intention to deliver the goods to the plaintiff against such payment. Then 8 and 9, my lord, kindly omit D, kindly omit, kindly come to F. The defendants number 1 to 5 acting in collusion with the defendants number 6 to 10 and 13 and 14 have taken so and so the plaintiffs directed to the factory of the defendants number 6 and 13 with an intention to deceive the plaintiff, and the defendants number 6 and 13 would supply their respective quantities under the third contract. Then my G also kindly come to the next page. The defendants number 1 to 5 and the defendants number such and such knew fully well that they did not intend to perform the third contract and made false and fraudulent representation to the plaintiff with the ulterior motive and malafide intent of defrauding the plaintiff of substantial sums of money. Then, my lord, it goes on.
Yes.
Lot of deceit touch.
Till K.
ডিসিটা আগেও আছে এফেও ছিল deceit is also there, my lord, in clause I, subparagraph I. My lord, similar pleadings for the other contracts are also there.
Yes, 144 is.
Yes, the other paragraphs are also there. Now, my lord, my short point before your lordship is this, that, my lord, I was deceived, I was induced by these defendants to make the payment. To make the payment over and above the contracted amount, and they proceeded in this manner that, yes, first two contracts.
Okay, then, okay.
And then, my lord, it goes on. Now, my lord, they have relied on certain decisions, my lord, about on, my lord, section 12A. My lord, the decision which they have relied on, revocation of, my lord, 12A, my lord, they have relied on 2022 volume 10 SCC page 1.
Yes, partial automation.
Partial automation, my lord, they have relied on paragraph 113.1. But kindly come to now first page. Your lordship has a copy, my lord. Well, it kindly come to, my lord, the first paragraph. First paragraphs, few paragraphs. Leave granted, the seminal question which arises for consideration is whether the statutory pre-litigation mediation contemplated under section 12A of the Commercial Courts Act 2015 as amended by the Amendment Act of 2018 is mandatory, and whether the courts below have erred in not allowing the application filed under Order 7, Rule 11 of the Code of Civil Procedure. There is no such application, be that as it may. Then paragraph 2. In civil appeal arising from such and such, the respondent filed a commercial suit under Order 37 CPC before the additional district judge court Faridabad, praying for recovery of such and such along with such and such. Then 3. The appellant is the defendant in the said suit. It filed an application on 5th February 2021 under Order 7, Rule 10 and 11 read with Section 9 and 20 CPC inter alia contending that the suit was filed without adhering to Section 12A of the Act.
Yes.
Now, this was the scope. My lord, in party automation, the question was, my lord, whether the suit can be filed without, my lord, pre-institution mediation and without leave.
Is it mandatory or not?
Absolutely. That was, my lord. Now kindly come to paragraph 99 once. Paragraph 99, we may sum up our reasoning as follows. 99.1, my lord. The Act did not originally contain Section 12A. It is by amendment in the year 2018 that Section 12A was inserted. The statement of object and reasons are explicit that Section 12A was contemplated as compulsory. The object of the Act and the amending Act of 2018 unerringly point to at least
partly foisting
compulsory mediation on a plaintiff who does not contemplate urgent interim relief. The provision has been contemplated only with reference to plaintiffs who do not contemplate urgent interim relief. The legislature has taken care to expressly exclude the period undergone, etc. Then, my lord, kindly come to 100. In the case before us, the suits do not contemplate urgent interim relief. As to what should happen in suits which do contemplate urgent interim relief, or rather the meaning of the word contemplate or urgent interim relief, we need not dwell upon it. Then, my lord, they have relied on 100.
Now, I think 2024 that has been clarified by Justice Supreme Court. That has been clarified with regard to that.
Yes, I have that judgment also, my lord. In fact, my lord, this honorable court, my lord, the division bench of this honorable court in 2 judgments, my lord, have said that, my lord, what contemplate is, my lord. May I show that, my lord, for if required? Gabriel today.
আপনার কাছে আছে আপনি ওখানে
একটা দিয়েছি
আচ্ছা
আরো চাই
না না
একই জজকে বল আলাদা ঠিক আছে হ্যাঁ Now, my lord, kindly come to the second page. Sorry, yes, the pagination is possibly at the bottom. The 3rd paragraph. On 3rd November 2020, the learned single judge of this court granted leave to the appellant plaintiff to institute the suit without undergoing pre-litigation mediation. On 4th July 2022, another single judge of this court, in an application for revocation of such leave and for dismissal of the suit, ruled that since for 2 years after the institution of the suit, no interim application for an urgent relief had been moved by the appellant plaintiff, Section 12A leave was liable to be revoked and the suit dismissed. An order was passed accordingly on that date. Now, let's kindly come to the last paragraph of that page. The question which has now arisen is whether the learned judge was right in granting the leave or whether the appellant plaintiff should have been compelled to invoke the mediation process and complete it before filing the suit. As the section postulates, if in a suit no urgent relief is contemplated, then section 12A leave is mandatory. Then, my lord, kindly omit the next two paragraphs. The legislature does not say that the relief should be urgently sought from the court, or the time period within which the relief is to be sought, or the nature of the relief to be sought to qualify as an urgent relief. The legislature only mentions that the suit should contemplate urgent interim relief. Very often, a purely literary interpretation of the words of a statute does not bring out the intention of the legislature. The intention has to be understood from a consideration of the entire act. Pre-litigation mediation was obviously introduced to reduce the number of cases filed and to promote alternate dispute resolution. Such an exercise was made mandatory whether the parties wanted it or did not want it in case of suits where urgent reliefs were not contemplated. Why this distinction has been made? This section stipulates 3 months' time from the date of the application of the plaintiff, which can be further increased by 2 months with the consent of parties for completion of the mediation process. Take the example of a suit for recovery of money lent and advanced. The defendant debtor has huge debts in the market. Several claims of creditors against him are pending. When the plaintiff is contemplating filing of the suit against him, he is in the process of transferring his immovable property so as to defeat the claim of the defendant as well as other creditors. Immediately with the filing of the suit, the plaintiff needs to move an interim application and obtain an order restraining the defendant from transferring the property and for the property, etc. Now, if the plaintiff is to undergo mediation compulsorily, the defendant might keep it pending for 3 months. For 3 months, the plaintiff would be unable to institute the suit and hence unable to obtain any relief. In the meantime, the defendant could be successful in transferring the property, thus defeating the claim of the plaintiff, hence the justification for the exception. Then, my lord, kindly, next paragraph. The legislature, in my opinion, has used the expression contemplated to express the intention that an interim relief may be required at the time of filing of the suit or may be required any time the defendant expresses an intention to do some act to defeat the decree to be passed. So the test, in my opinion, is not whether an urgent interim relief is immediately required, but whether the averment in the plaint points to a situation where even before expiry of 3 months, the plaintiff may have the need to obtain interim relief. Then, my lord, kindly come to, my lord, the judgment of Justice Chaudhary, my lord, which starts at page 6. The separate judgments were given. My lord, kindly come to page 7. My lord, the penultimate paragraph, starting with although. Although there is no straitjacket formula regarding urgent interim relief, but the same has to be considered from the nature of the suit. All courts have inherent power to do justice. Thus, while granting leave under Section 12A, the Commercial Courts Act, courts must consider nature of suit, irreparable loss which the plaintiff may suffer if leave is not granted, and the abuse of the process of law if such leave is refused. Pre-institution mediation is provided for the purpose of amicable settlement of disputes prior to moving of court. But such procedure should not be used by a defendant to delay the resolution. Then, my lord, kindly turn the page. My lord, the second paragraph, Section 12A of the Commercial Courts Act 2016 provides power of the court to grant leave to institute suit without exhausting the remedy of pre-institution mediation, which includes power to refuse leave. Nowhere in the statute provides power and condition by which leave granted under Section 12A of the Commercial Courts Act can be revoked. Although there is no specific provision in the Commercial Courts Act regarding revocation of leave granted under 12A, but the courts under exceptional circumstances may revoke. Ultimately, my lord, it was kept. Now, my lord, there is another, my lord, it's not a judgment, definitely not a judgment, my lord, it's an order of this same division bench Kanti Chaudhary নেই না ঠিক আছে
Yes.
হ্যাঁ এই দিয়েছিল ঠিক আছে ছেড়ে একই কথা বলেছে হ্যাঁ দেখো নাকি ছেড়ে দেবো next my lord kindly come to ওটা কোথায় রে 2024 এসএসসি অনলাইন ডেলি না না হ্যাঁ এটা কার
এটা ওদের এগুলো সব ওদের
ছিল তো দেখাবো My lord, the Jamini Monohar, my lord, reported in 2024 volume 5 SCC 815.
Yes.
Yes, that is.
And lordship is out. বলছিলেন
Yes, my lord, Justice Khanna is my lord. My lord, kindly, yes, kindly come to my lord, paragraph 5.
5.
Huh?
প্যারাগ্রাফে জজের প্যারাগ্রাফ মিলছে না
কেন রে
এটা এসসিসি অনলাইন প্রিন্ট আপনার এসসিসি প্রিন্ট
Oh, my lord, kindly give me a minute's time, my lord.
Print is not, paragraph numbers are not matching. Can do that.
Yes, paragraph 5, section 12A. Any difficulty?
We've got another, my lord.
My lord, I got, my lord, the SCC online. At that time, it was not, my lord, reported in SCC. So, my lord, it's completely, the paragraph numbers are completely different. It changes, my lord, when it is reported, my lord, in SCC. Now, kindly come to paragraph 5. Section 12A of the Commercial Courts Act does not contemplate leave of the court as is clear from the language and words used therein. Nor does the provision necessarily require an application seeking exception. An application seeking waiver on account of urgent interim relief setting out grounds and reasons may allay a challenge and assess the court, but in absence of any statutory mandate of rules made by the central government, an application per se is not a condition under Section 12A of the Commercial Courts Act. Pleading on record and oral submissions would be sufficient. Oral submissions. Then 7. In the present case, it is an accepted fact that an urgent interim relief has been prayed for and the condition that the plaintiff contemplates an urgent interim relief is satisfied. Therefore, the impugned judgment, etc. Oh, এটা পুরো চেঞ্জ হয়ে গেছে
চেঞ্জ সিসি তে এসে চেঞ্জ হয়ে
it creates extreme difficulty, my lord, because the reporting in, my lord, it changes. May I kindly come to paragraph 10. Which, my lord, was possibly sought to be relied on. We are of the opinion that when a plaint is filed under the Commercial Courts Act with a prayer for an urgent interim relief, the commercial courts should examine the nature and the subject matter of the suit, the cause of action, and the prayer for interim relief. The prayer for urgent interim relief should not be a disguise or must to wriggle out of and get over Section 12A of the Commercial Courts Act. This was the portion relied on possibly by someone of them. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff. Non-grant of interim relief at the ad interim stage
That
when
cannot be.
complaint is taken up for registration, admission and examination will not justify dismissal of the commercial suit under Order 7 Rule 11 of the court. At times, interim relief is granted after issuance of notice, nor can the suit be dismissed under Order 7 Rule 11 of the court because the interim relief post the argument is denied on merits and on examination of the three principles, etc.
This point
Huh?
is a prime fishing case. Their representations that money which I paid to D1 was forwarded onward to D6 and D10. चार्टे मैंने तो actually नहीं था।
नहीं, ये तो केस को लेके देखिए।
एक बजेगा तो नहीं है
तो एक पूरे केस में डिस्टिंग्विश करता हूँ।
One pay fixed. One pay fixed.
How much time will it take?
I will take some time.
ये कल भी है नहीं ना कोई और आ जाइए लास्ट टाइम एक ही दिन फिक्स
But one thing, my lord, I'm led by Mr. Ghosh. He has joined online, Mr. Dhruva Ghosh. I have one judgment to place before your lordship. I could not place it because the printout was not there when I argued the matter. I'll indicate, I'll place it on the next occasion. It is
do one thing,
2024.
you give the copy to the
I'll
other
give a copy.
side.
I'll give
the
a copy.
next date when Mr.
Mr. Ghosh is there online.
I'm here.
Ghosh will place, then I
So one thing I should have pointed out earlier, but there has been no compliance of Order 39. I will indicate on the next day.
Yes, Mr. Ghosh, you serve the copy to the plaintiff on the
Yes,
next
my
day.
lord. Yes, I'm sorry, my lord. I got stuck in traffic. I came home. I was getting late.
No problem, no problem. It is
Sorry.
Decision. Good decision.
So appearing for the plaintiff. So appearing for the defendant number 1, 2, 3.
45. 1 to 5 possible.
1 to 5. You are appearing for 1 to
1 to 5.
1, 2, 3, and 5,
1,
not
2,
4.
3, and 5.
1, 2,
Comma.
3, and
So appearing for the 6 and 7, and so appearing for the 8. 10. Counsel for the plaintiff has argued at length in connection with GA1 of 2024. But due to paucity of time, hearing could not be completed. Give the date.
No.
19 ज्यादा मैटर नहीं है 19th August.
Well, the section 45 is fixed in September, but and 19th is okay.
19th. Because other dependents are also there. Let us see.
Only thing is, my lord, the interim order is till 19.
19 I am fixing on that. No.
Actually, Mr. Mitra is of the apprehension, rightly so, that it may get vacated on the 19th.
No. That can be vacated, my lord, whether I have the apprehension. My only apprehension is, my lord, in case, my lord, it so happens on occasions that, my lord, from the morning there is no, my lord, we refrain from.
Hey, come karo.
Can it be? Can it?
37 karo. फिक्स है 12 बजे का कोई मैच 12 बजे कौन सा दिन फिक खाली है 12 को 20 Friday 23rd at 12 noon.
Then, my lord, interim order can be extended till, my lord,
full stop interim order which is going to be expired on 19th.
Yes,
19th August is extended till 27th of August.
23rd August.
Can it be 22nd, 23rd to 1st? I'm not there.
You are having something.
Your lordship said 19th. Let it appear on 19th, and the interim order
19th.
may get extended.
Full stop. The interim. Let it come. If it not, the court will see to that. Come on 19th.
No, I will be there on 19th, my lord. Only I was humbly submitting that, my lord, the interim order can be extended till 20th or 21st, my lord.
The interim order which is going to be expired on 19th of August 2024 is extended till 23rd 3rd of August
Yes,
2024 or until further order, whichever is earlier.
Great. But in this, the matter that's fixed at 1 p.m., I appear for the petitioner,
Yes.
Mr.
And
Shoma
he-
Ghosh is my junior man.
So, and then-
They sat yesterday, they had sat. Now
Yes.
they have refused to let us put the panel where the existing panel is. And there was a dispute and they could not compromise, come to an understanding. So, my lord, the special officer will have to be appointed at least to hold a meeting, and otherwise your lordship will have to decide. That is my submission. And after all this, my lord, when we had the meeting, they relied on our report, and our report said the panel can be fitted right next to the existing panel. Now, the problem is, where will we put the panel? And they have said that our existing panel is in their area. It's in the common area. It's in the basement. Now, they don't want us to put the panel there. So it's an impasse, my lord. Your lordship will have to decide. We tried. And my learned friend on the other side, my lord, we were supposed to sit. The clients have sat. They are not on good terms.
The minutes are here, my lord.
So we
I
couldn't
thought, Lord, it can solve a lot of, my lord, inter-say factual exchanges if the persons concerned sit and decide. So they sat in the presence of advocates. There's only one crease that is to be ironed out. No one says that new panel should not come in. That has to come in. The question is, where does it come in? Just beside the panel which is there existing, or does it come in at the designated place where the chief electrical inspector had found a place in the building for the purpose of an installation, a fresh installation? Does it come in there? Because the chief electrical inspector in his report dated 7th of February 2024 says that as far as the space concerned for any new installation is concerned, the rear side southeast corner of the backside building, that's the rear building, at ground floor is the space which is available within the building. I'm reading the report of the chief electrical inspector dated 7th February. Supplementary
So I think, my lord, Mr. Banerjee is trying to completely confuse the issue.
No, I'm not.
Absolutely.
No, my brother will kindly not.
No, that is absolutely the
my
case.
brother will first try to trust me, and then
No, I have with the entire trust that I have, I've trusted
So
Mr. Banerjee.
first,
but
let
his
us
client is completely on a different
First,
boat.
let us see. Let us see, my lord, whether this can be, if it can be sorted out well and good. Otherwise, adjudication is always.
Obviously, it can't be.
There is no.
Wherever his panel is, I'll fit it
Parties are
beside
ad
it.
idem. If parties are ad idem that there is requirement of a panel. The question is the space. Now there are two spaces. There's one space which is the chief electrical inspector's suggestion. If your lordship kindly sees the 7th February 2024 report, that
is the one new one, 750 kVA.
That's completely different.
No, that was the suggestion.
Absolutely different.
My brother, that
Let-
was the
let- let- let
that
me
was the
hear.
suggestion coming on behalf of us that a new compact substation needs to be installed. He said, even if you want to install a new compact substation or anything new installation you want to make, please make it on the rear side, southeast corner of the backside building and at the ground floor. Now, this is the place where the new thing will come in. The new thing is cumbrous compared to the old one. The new thing is cumbrous. If two are beside back to back, there may be problems. Therefore, to obviate that, kindly put it in the place where the chief electrical inspector has identified for a substation, which is much bigger than that of a panel.
The old
That's
station
the only
will be
suggestion that was
removed.
going. Now, all the parties are ad idem here. I find that there is no difficulty whatsoever.
But the old station will be removed after we put it. So there's enough space they will have. And it's in the common area.
I couldn't understand that part, because if they put it beside it, then the question of removing the old station doesn't arise.
Once the new panel is fitted, then the old thing, that space is opened up.
So if you say that this is the
If the space does, I'll tell you, lordship. If Mr. Ghosh's clients or Messrs. Ghosh's clients are agreeable to the fact that this needs to be put in the portion that is identified within the rear side building at the ground floor, southeast corner on the rear side, which is really a portion which is available for an installation, and that installation is electrically permissible. It's feasible also. We've taken instructions, it's feasible. Now the question is whether they select that spot. I don't think it will be much of a problem for them, because from that spot they can operate it. This can remain in a place which is away from the actual partly dilapidated panel that's there. That will obviate a lot of difficulty.
Now the panel.
Yes. They want to install it beside. And if they install it beside, it's a huge one. If they install it beside, it's going to eat up area. It's also going to be, but this area happens to be my area. But then that's neither here nor there. One can come to that thing, that finding later in the suit after the trial. Now, for the purpose of immediate bringing in of that panel, the space which both parties have found to be the space identifiable for installation of even a 750 kVA CSS, the panel can be installed there. And the chief electrical inspector has said that the LT panels, as per number of individual occupiers, may also be installed at the ground floor attached to the proposed CSS location. Please see mirror 2A and 2B.
That is if the CSS is put.
That's
is not being put. This is a temporary arrangement, my lord.
Yes,
so total requirement is 750.
Total requirement is a replacement of a panel. The 750 and 250 lot are there. They are connected in the ways that they are. What they are wanting to replace is a panel. Panel is nothing but a glorified switchboard.
Correct.
Now, if they put that glorified switchboard in a place where
already there is an existence of
an existence of a switchboard or a huge old panel. Now, the moment that comes out, they want to place it beside it.
Why beside?
That is what they are saying.
Same. No. This is where I'm joining issue. Mr. Banerjee has been very efficient in obfuscating the issue.
So, if it is an old one, the old panel,
old one will go out, new one will come in.
The dilapidated condition, that will be removed, and they will fit the new one.
I don't think that suggestion came, because if that would have come, I'll tell you, Lordship.
That is the entire issue. The issue of installation of a substation is not the issue.
Because earlier they wanted to one, now they wanted it should be segregated into two parts. One is the 750, second is 250. So now they are ready to give their two panel now, which is to be where it is to be fitted. So earlier already then existing panel is there. So that existing panel is in dilapidated condition. That is to be removed, and new panel is to be.
That is all. That place and its immediate precincts are not feasible for taking in an additional panel. They can.
No, there is no additional. Why is Mr. Banerjee misleading this court?
These are strong words.
No, absolutely correct. Because the case is there's no question of
obfuscate, misleading. They are very good when they sound at the bar. We are here trying to solve something. I am saying please, brother, we can save on hours of judicial time if we can get into this within another 5 minutes.
If your client would have been fair to the court.
No, if you stop quibbling here, then we can do it. Otherwise, we can come on in affidavits and this can end at the end of time. That is not the issue here. Please bear with affidavits. I am saying, as far as the panel that is there is concerned, what they are wanting to bring in by way of these two attachments is an additional area beside it. That's what he's saying.
No,
that's what he's saying.
Additional area is required.
When it is first the panel is fixed, it will be right beside the new panel. Then the wires will be changed. The new one will be removed. It can't be. If the new one is removed totally, I won't have electricity for a long time. It's only for fitting. It will be kept next to it. And there's a space next to it. And they will get back this space. Anyway, it's according to us, it's common area, but that's a matter of the suit. The existing panel is there. We want to fit it there, but obviously two can't be on top of each other. One will have to be fitted, then the other one will be removed.
Let this be done.
So that was explained to my learned.
That was not explained. Contrary to what may have been instructed to Mr. Ghosh, that was not the idea given. Mr. Ghosh will kindly bear with me for a moment.
That seems logical to me. Okay.
The idea was that was given was in that additional supplemental space, this huge new installation would be put. Now, if that is the suggestion going in, then automatically no one who holds space to his own would volunteer to give it. Then the question came as to which is the other place available. It could be shown, my lord, from the chief electrical inspector's report that the ground floor rear side southeast corner is a designated place where they are even permitting installation of CSS if possible. So a compact substation, which is a much bigger gargantuan, can be put there safely without any of the parties getting disturbed. So that space was identified. Now Mr. Ghosh is saying that no, we want to just replace it. If the area remains constant and only replacement and then the remaining part can be done, then perhaps there can be no difficulty. But that is perhaps not what Mr. Ghosh's clients, experts are saying. They are saying we will put it up in additional space beside the old one.
And the old will be removed, so they won't lack any space. That's my thing.
No, additional space is being taken. I'll tell you, Lordship, this can also be sorted out. This is also not problematic. It will be difficult for court to sort it out because a special officer will have to be appointed. He will hold fact finding. He will find some facts. There'll be five exceptions, and ultimately the entire thing will ultimately head towards trial. So, my humble
Mr. Banerjee be the special officer.
No. I'm certainly not. In a matter in which I am appearing as a counsel, I would definitely never be a special officer. Only one prayer I have. In the event they are able to show that there is no excess area which they are consuming, then I think all is fine. The impression given was we are going to consume the area beside that panel, and that area will be an additional area within your area, which no one will concede to because the parties are at loggerheads. I wanted to bring both of them together under an umbrella for the purpose of kind of a without prejudice interim arrangement. Now that's the only difficulty. Mr. Ghosh's experts who were there with Mr. Sharma, who represented his client, could not in fact say that the area would remain constant in terms of utilization of that part. They are insisting on an area being additionally used. That, my lord, would be difficult. For that, a designated area has come.
Why the additional is required to be used?
They are saying that because the new ones are huger and they are in two parts, they are huge installations, so therefore additional area will be. And that's my area. So the question is now, why don't we then, I'm asking myself, find an area which is common to both and which is feasible for both, which is the area designated by the chief electrical inspector.
So that was the object of the meeting, but it hasn't happened.
I think, Lord, we are not at loggerheads. We are ad idem on this. The area, if that is chosen to be without prejudice, then no one will be affected. And we'll extend our full cooperation. In fact, client, I think, went on record saying that they will extend their full cooperation. He's ready and willing. May I just quote from the minutes, though they are not officially transcribed, perhaps. He is ready and willing to cooperate and give full assistance to the petitioners to install a new panel board and transformer in the allocated space. That is the space that is found here by the person, by the chief electrical inspector.
Chief electrical inspector was on a different topic.
He then submitted that he is ready and willing to cooperate and give the full assistance to the petitioners to install a new panel board and transformer in the allocated
Yes.
space.
I'm sorry, I missed two lines. But kindly see, what he will not allow the petitioners to install the new panel board beside the existing one, because the new panel board has been manufactured by a local manufacturer and is huge in size. So it eats into the extra additional area. It creates a hazard also.
Huge in
Now, he didn't suggest, Mr.
in size, and the place where the petitioner want to install belongs to the respondent number 1 and 2.
That's
and
us.
He has also stated that his earlier occasions, CSC Chief Electrical Officer rejected the said installation. Yes.
So he is saying that part, let it not be chosen.
So Mr. Ghosh, why you're not accepting the chief electrical inspector?
No, that was completely different, Mala. That was he wanted to change all the transformers and put a compact or CSS transformer.
Correct.
That would have to be, they have advised that such a thing is not safe in the basement. So that was to be going to the ground floor. That's completely a different issue. Here it's in the basement, it is treated as common area where it is existing. Now, obviously, it has to be beside. Now, my learned friend says it's his property, or if it's common property, that is the dispute. That has to be decided in the suit. But if I have to fit A instead of B, I have to first fit A, then remove B. That B space will be his. If it is his space, we can arrange that. But it has to be fitted close by so that it can go in.
I'm sorry. But that was not what was the impression sought to be given. The impression sought to be given was the old one stays. The new one, which is huger in size,
the old one will not be required after the new one is put in.
Why is the area difference in the area?
Yes, the difference
area will be quite a huge difference, because they say that the installation of the new one will involve putting in of new toggle switches, etc., which are much wider in terms of the new technology.
How much area access it will be take?
You haven't made the second
instruction. What we can do is this again. Well, this is again if your lordship permits us. Otherwise, not bringing this at the interlocutory stage to the court would be embarrassing the court, because the court sends an officer. Officer is not an expert. Even if he's an expert,
So now the only question with regard
which
to
is the space, which is the area.
Not which is the area. Now, what Mr. Ghosh clients want you are telling that if that has been utilized, so your some area will be affected.
Yes.
That is your question.
Yes. So
how
if
much
that is
area
not
it will-
affected, he's saying the total area occupied by the old panel plus the extra area which is taken for the new panel, everything will be used.
But after that, the old panel,
I'll
they
tell you,
can
Lordship.
take that area.
It is
after
not
the
as if, I'll tell you,
old
Lordship,
panel-
Lord, let us say if we want to install a furniture in the house, if we bring the parts of the furniture, we assemble it and then we put it at a designated place. If we had this idea in mind that this assembly is for the purpose of creating that furniture, putting it in, setting it in, and then you put it there, replace the old one.
Correct.
That is not the concept. The concept that now they are saying is the old furniture remains where it is. I bring in a new chair and I put it beside
Is
it.
absolutely
The new
not.
chair is bigger than the older chair.
That is
How it-
not. That is not
That is
even
what
the.
he's saying.
Absolutely not.
I'll tell you, Lordship, this comes
whether,
up.
whether the panel has been
Yes, yes, we've prepared and it's been ready for long.
What is the no?
Now he is not
second
permitting
panel
me
has
to
to
put
be
it on the
made.
650.
The dimensions be
area it
shared.
will take, whether more than the
More
earlier
than the
fixed space.
earlier panel.
So that how much area exact configuration that we have.
Come back.
Now, my lord, apart from that, what they did when we prepared the panel board, your lordship will kindly recollect, they removed the supply from the 650 kV to 250. No. Let me complete my submissions, Mr. Banerjee. I have not interrupted you. Now, my lord, what he does is, now he goes back on his word, saying that yes, we'll cooperate and we'll permit the petitioners to put in the panel board. They now say, go back and going completely contrary to their own affidavit. They say, no, you set up a new compact substation in a space allocated. That's a completely different
Compact
issue.
substation.
The chief electrical engineer
My lord,
inspection engineer was of the opinion that the entire transformer, it's an old transformer based on oil systems. It should be replaced and a fresh CSS should be installed. That is not the issue before your lordship. The issue
one minute,
with
Mr.
regards
Ghosh.
to installation of panel boards, Mr.
Well,
Banerjee
let
has
us
been
come back
successful
tomorrow
at
with the
kind of-
measurement.
Go ahead.
I thought
We'll come back with the measurement. It will not be, it's not something that the old panel stays and the new panel comes in. Old style panel is occupying one space, new panel is occupying another space. That's not the case, and that has never been our
My
case.
brother has just beaten me in the record of speaking as so rapidly that one cannot stop it.
No, only the question is that your apprehension that if the
If it
new panel
consumes
is-
additional area.
No,
It has boiled down only to that.
Firstly, my lord, it's not his area.
He's telling
Please,
their
brother,
contention
please.
is that their
If
specific
my area is 10 square unit, then if your panel takes 20 square unit, then according to me, those additional 10 square
what
units,
you are doing with regard to that area? What
the area beside it
Ah.
is being used for other installations, other infrastructures, ACs, various ducts, various things are there. It is difficult. It is difficult.
It is in the basement. There's
I'll tell you,
nothing.
Lordship. I'll tell you, Lordship.
basement in
No, it is necessary.
Lordship will kindly
So
see
there
page
will be
149
The
of the
special
application.
officer is there in the other suit. Let him go and see.
I'm only
Please.
saying.
Now we are only on the
Ground
area.
floor
We'll come back with the measurements.
In the
But the
ground
special
floor
officer
area that
should
is
decide this.
identified. Mr. Ghosh's clients and my clients are at loggerheads on the question of whether the CSS would be required or not. This is something which will come at the time of trial after expert evidence. Now, CSS, the compact substation, was to be housed and its additional panels were to be housed in a portion of the southeast corner. That's a demarcated place where installations of electricity can come in. Both chief electrical inspector has said this, the CSC has not denied this. Under such circumstances, CSC also says that the compact substation, etc., can be put in at the place where the chief electrical inspector has shown. This is the CSC's report dated 11th March 2024.
Which again has nothing to do with the issue at hand.
So
Yes.
when we are putting in this new additional infrastructure, why don't we put it in that place which is designated by both the experts?
No, it's not designated. They have said it can be used. Does not
If
mean that it's
all
been
the
designated.
transformers are changed, not in the present situation.
What
And Lordship will kindly take my application, page 148 and 147.
The application is to be taken up
The
on
pictures, just show him.
Yes,
the
yes. If this is the approach of my learned friend's client, we have to argue on merits.
Lord, I'm just submitting that if Mr. Ghosh can give us the total area which his new panel will consume.
Why is this issue being brought up today?
That issue was brought up on the earlier date.
Absolutely
I say
not.
If there are any quizzes, it will be ironed out in court. Let us first sit. We've sat. There's been a lot of consensus. There's only one
There is
point.
no consensus from Mr. Banerjee's client.
There's one tipping point now. There's a lot of consensus.
Yes. Then
Well, only one prayer, Lord, I had. If he can come up with this detail, and I can also come up with the detail of the area which has been designated by the Chief Electoral Inspector. If your Lordship permits us, then my Lord, on any day which your Lordship fixes,
see,
we can
every
come.
time you are changing your step.
Yes.
When kindly see the order.
Yes, yes.
On that day, you have not raised that order. Otherwise, this court
Yes.
have directed the chief electrical officer to see this. Kindly come to the 20th June order.
Yes, yes. 20th
Kindly come to the 20th June order
Yes, yes.
and page number 5.
Yes.
Page number 5, second paragraph. The counsel for, please read it.
Page number 5, my lord, second paragraph.
Counsel for the plaintiff submit that the plaintiff has already prepared the panel of so and so and is ready to fit the same. Counsel for the defendant number 1 and 2 submit that they have no objection if the plaintiff fit the said panel prepared for 650 kVA, but in addition to 650 kVA, the plaintiff has to further panel of 250 kVA for the same load has been distributed from the said panel. The counsel for the plaintiff disputed the submission so. So you have admitted that the note they have
It is
prepared
required to be. It is required to be done. I am still admitting it. There
Then-
is no change in that. It's only the place where they'll put it in.
When
How
the
can
already,
please change?
already when the old panel was there, they have prepared this. So now why you wanted to take backside of the or any other places?
Panel in the ground floor, southeast corner will be a safer and better accessible
but you
position.
should have
Something
mentioned
else.
that.
Here, my lord, the only question that arose, subject to what falls from your lordship, my lord.
You have not stated that it is to be given a separate area is to be fitted and all
That
this.
is completely. They wanted to.
issue.
They wanted to fit a panel for 650 kVA.
That is already
In
there.
addition to that, the plaintiff has to fit further panel of 250 kVA.
Because you have segregated in 2 parts.
Yes, yes, yes.
So they have stated that they are ready
They'll
to
do
make
both.
it 2
Yes,
parts.
if they do that, the question is where would they do it? If they do it in a place which is common to
where
both,
the
then there's
where the place is,
Where it is existing.
I'll not change it. How can
Where
I
it is
change it?
existing.
the existing one beside it, if it comes in, then what is going to eat up
There'll be
additional
nothing
space.
which will come in. There'll be nothing which will be going out. Mr. Banerjee's client knows this. I think he has been completely
It is for the public interest. This place, this court will not consider.
This has to be installed.
It has to be installed.
So
This is for the public interest.
Here I am not here I am ad idem. I have always, my lord, I bow down to what is
For the
what falls
2
from your
feet,
lordship.
2 foot discrimination.
Not even 2
5
feet.
for-
Will be a
45
few inches
meters
here and there.
for the
Because
purpose,
if
it
it
is
is a-
for the public
Yes,
interest. There
yes.
is a report. It is a dangerous.
Yes,
condition.
yes, yes.
The panel is to be changed.
I
it is
bow
to be
down.
changed.
I bow down. I bow down.
Then
I bow down. There's no difficulty. I'm only simply submitting that if it is only a question of minuscule 1 or 2 or 3 or 4 square meters, there is no difficulty.
Square meters.
Now the question is no. The question is the representation given to us was that the panel will be brought in fixed beside and both will be kept side by side.
But why will I need this old panel once I put my new panel?
No, it is not there in this affidavit. It's not there in my
If you
petition.
want, I can file an affidavit.
No, not required.
That is why
Because
we
the
said.
affidavits are already there.
Well, that is why
These
we
facts
said.
are coming in from I don't know where, from which wonderland.
No, it's not coming from any wonderland. It's coming from the parties coming to know about each other's stand while sitting.
because every time you are coming
The
with one
panel has to be
one
what you will
after-
kindly conceive of this.
Lord,
There's a switchboard. It's a switchboard. Switchboard, my lord, if it's an old switchboard, it has to be removed, kept in the side. New one which has been brought in, that will be installed.
If
Now,
that
for
is
the-
done, if
that
that
is
is
all.
done, there is no difficulty whatsoever.
That is all
Then
that is
there's no
done.
I'm saying it be done beside.
Where is the question of beside?
I don't think beside is telling.
Nobody is saying anything of
Beside is, my lord, beside is
purpose of
because it
keeping
has to, the corrections have to be made first, and then that old one will be removed, and then I'll put it back on that place if that is
Yes,
necessary.
temporary.
But it has to initially be made beside.
There's no
Otherwise,
question of
I'll
beside.
be out of connection.
For the temporary, some
Yes.
What has come? I've got
Yes.
what has fallen, my lord, from your lordship, lord. I've understood. What Mr. Ghosh wants to say, my lord, I've also understood. Only one prayer I'm making. If your lordship can keep it over the day, I'll just have a talk and I'll come.
Well, it's not dependent on my
No,
learned
this
friend's
is-
client's
that is just-
instruction.
Listen,
Why,
I can
Mr. Ghosh, you understand?
I can understand.
For
He's saying,
changing all these lines, for the time being, some space is required.
Yes.
They have changed. Then when this has been fitted, this has been shifted, automatically the same space
that
will
is all.
come.
Then there should be no conflict on that.
Since beginning, Mr. Ghosh is telling that.
Mr. Ghosh's clients experts didn't say that. That's the whole
That is the
difficulty.
entire
That's why I
Client
told
may
you.
say many things.
So I'm saying, Lord,
To solve the purpose,
Lord,
the
I'm
word,
humbly
the
submitting.
advocate has to.
Yes, he has to rise above the client at certain occasions. Lordships know, my lord. Lordships were with us, my lord, at the side of the bar. My lords have seen this. But the difficulty is not that. The difficulty is the transparent and linear manner in which Mr. Ghosh has put it is not hardly the manner in which that was put there. He said we'll put in an additional area, consume
Not
that area.
additional area only for the temporary measure till that has been.
So that has to have a timeline,
Yeah.
some timeline.
That can be.
Yes.
That's
Then
why
work
you're
out
telling
the
that
timeline.
either a special officer will
Yes.
Yes,
take, or any engineer can be. He can.
he
execute
can
the work,
do that
whatever
within a
is-
timeline to be fixed by the court or
So
something like
fixes
that.
the time.
So therefore, let me just come back on this. Let me just come back on this.
tomorrow
I'll keep it. Look, tomorrow, yes, yes, tomorrow is fine. I just thought tomorrow is 15th August.
फिक्स है कब है परसों 19th come on 19th that
Yes, come back on 19th. Well, we'll come to
Census
Come back.
the plaintiff census suffering for the defendant counsel for the respective parties argued at length due to paucity of time matter could not be heard at length police counsel for the defendant press for time to take instruction let the matter appear on 19th August at 1 p.m.
Obliged, Your Lordship. Extremely sorry. He mentioned item 27. Your Lordship had asked my junior to wait. My Lord, it's an infringement and passing of suit. My Lord, what I was saying was 2 o'clock. Your Lordship has fixed my other matter. I will convince Mr. Jishtu Chaudhary would be addressing Your Lordship. I will convince him to address Your Lordship for 45 minutes. After that, that 15 minutes of mine, may I just use this for a matter? It's an ex parte. We will be moving.
That's why I told you junior because he's telling the the list matter is mentioning. I thought this court is not so slow. The matter cannot reach the 27.
I will at 2:45 it can be taken up. I will convince Mr. Chaudhary.
Let me see. Sometime the matter adjourns.
Yes. No. We know, my lord. This item 17 has been going on for so long. That
is your matter.
Yes, my lord.
May I have Your Lordship's kind leave to mention item 32 of Your Lordship's commercial list. The only difficulty I'm facing, Your Lordship, is the interim order in the matter is expiring today.
Come at 4. Come at 4.
Very well.
Yes.
Item number 18 of the commercial list.
I am here on behalf of the plaintiff petitioner.
Item number?
18.
This is my injunction application.
18. Yes.
This is my injunction application. So
which for the other side?
So Mr. Sorojit Dasgupta was appearing for the respondent along with Mr. Rudraman Bhattacharya. So I'm being led by Mr. Jishnu Chaudhary, but I have instructions to commence the arguments, Your Lordship.
Yes.
But my injunction application is restricted to the fact that I, having executed a restricted deed of guarantee in favor of the bank, and the bank restricted to the value of the flat, and the bank, having sold that flat, appropriated that money, is now not issuing me NOC. That is a no objection certificate. Now, Your Lordship, if the documents now
how the amount is surfacey?
No, Your Lordship, surfacey. Your Lordship, I'm a personal guarantor.
Okay.
The main company has gone into CIRP, that's in before the NCLT, but I was only a personal guarantor restricted to the value of the flat. That is recorded in the deeds. I'll place those deeds. In that circumstances, Your Lordship, and on the fact that the bank not having been able to place any document on record to show that my deed was unrestricted, Your Lordship, they cannot proceed against me for recovery of the balance amount. Your Lordship, may I? Your Lordship, the petitioner is the wife of one Om Prakash Dhanuka, who is a promoter and director of a company called Riga Sugar Company. Lordship, the pleadings are complete. The written notes are also on record.
Written notes also there.
Written notes also on record. Your Lordship, this has been argued thrice.
Preliminary written notes.
Once before Justice Saraf, thereafter before Justice Kapoor, Justice Mukherjee.
Why so much hearing?
Lordship, it was so that every time it was argued, there was a change of determination after that, after completion of arguments.
No,
nothing like that would happen here.
We are in August. Yes.
Hopefully, it will see the light of the day now. So, the petitioner is the wife of one Om Prakash Dhanuka, who is the promoter and director of the company called Riga Sugar Company.
Okay.
Now, the petitioner had agreed to provide this restricted personal guarantee in favor of the company.
Okay.
Restricted to the value of the flat, which is in Delhi. Now, Your Lordship will kindly take up my petition.
Delhi?
Delhi. Your Lordship, the flat is situated in Delhi.
How cause of action here?
Lordship, because the company and the personal guarantee documents are all
Calcutta.
in Lordship. Lordship, there's no dispute with regard to the jurisdiction.
Okay.
Lordship, page 66 is the deposit of the original title deeds. Page 66 of my application.
66.
66.
Yes.
Lordship will find a letter from the petitioner, that is Meera Dhanuka, to Bank of India, that is the respond number 1 herein. Simple deposit of original title deeds of such and such dated 6 May in the name of Meera Dhanuka in respect of flat number such and such, Greater Kailash, New Delhi. With reference to your sanction letter such and such, which were further modified by letter such and such, dated in favor to Riga Sugar Company Limited. Please find enclosed herewith the original title deed in the name of Meera Dhanuka. Now, Your Lordship, thereafter there was a deed of guarantee executed, which Your Lordship will find at the very next page. Page 67 is the deed of guarantee.
Yes.
Your Lordship will find on the right-hand column the deed of guarantee executed by Meera Dhanuka, that is the petitioner. And Your Lordship will find at the top Bank of India.
Yes.
Now, Your Lordship, I'll just show the relevant term. Your Lordship may kindly turn to page 70.
No. In whose possession the flat is?
Lordship, the flat has been sold to a third party. Confirmation of sale by the bank. The money has been appropriated. Lordship, the confirmation of sale, the deed of conveyance, all are on record.
Now what you want?
Lordship, now the
amount is to be secured.
No, Your Lordship, I'm not saying. Your Lordship, may I take Your Lordship to the prayers of the application? Lordship, they are not issuing an NOC to me. They are saying it's not a restricted guarantee, it's an unrestricted guarantee.
In spite of the
in spite of these deed of guarantees, and there are numerous recordings which show that it was restricted to the value of the flat.
Okay. Next.
Lordship, 67 is the deed of guarantee. May I just show the relevant clause at page 70? Clause 2, Your Lordship, right column, second half. This guarantee shall be a continuing guarantee for the purpose of securing the whole of the monies, actual and contingent, mentioned in clause 1 hereof, subject to the aggregate principal amount under the said credit facilities, not exceeding. Also, may kindly mark the words not exceeding rupees 6 crores 94 lakhs, together with all interest thereon or on such sum as may be due at the rate of 4.8% over the base rate presently at 14.5% monthly rents. Your Lordship, here it clearly states not exceeding the value of rupees 6 crores 94 lakhs.
Yes.
Now, Your Lordship may kindly turn
Together with all interest thereon is due to the 4.8 of 4. Yes. And then
kindly turns to page 87. So this is a notice sent by one Sanderson Morgans. Your Lordship will find this is a copy has been marked to Bank of India as well as the company, page 89.
who has sent this notice?
Your Lordship, this is probably the legal head of the consortium.
By whom? By whom? Whose paper?
Lordship, the clients are not written, but this is Your Lordship, subject to correction by my learned friend, the legal advisor of the consortium of banks that had advanced money. Lordship, because Your Lordship will find a copy of the letter was also marked at page 89 to the company.
Rega Super.
And Your Lordship will find the heading at page 87, the subject, preparation of draft joint consortium documents of term loan. So, Your Lordship, this was probably the legal advisor of the consortium for preparation of the consortium agreement amongst the banks. Now, Your Lordship, in this page 87, the very last paragraph, with regard to the guarantee, we have been given to understand, although Meera Dhanuka, that is the petitioner before Your Lordship, will furnish guarantee in favor of the Bank of India and Union Bank, but her guarantee will be restricted to the amount of the term loan or the value of a residential property at New Delhi, whichever is lower. And such guarantee will be confined only to the term loan of rupees 9.25 crore and term loan of 16.78 crores. Accordingly, we have modified the drafts of the consortium term loan documents.
Will be confined to only the term loan of rupees 9 crore 25.
Lordship, there were various term loans by various banks. Therefore, they had come up as a consortium. So, Your Lordship, this has been made, the guarantee is only restricted to 2 of the term loans. That's what it is recorded.
But with regard to your is 6 crore
94 lakhs, Your Lordship, or the value of the property, whichever is lower. So, Your Lordship, that's recorded in there. This is at the time of formation of the consortium agreement. So, this is a letter by their legal advisors, a copy which has been marked to the company, which I've got hold of. So, here also it records that, but her guarantee will be restricted to the amount of the term loan or the value of a residential property at New Delhi, whichever is lower.
Correct. Stop.
Lordship.
And
such guarantee will be confined only to the term loan of 9.25 crore and 16.78 crore. Lordship, these are 2 term loans. Your Lordship will see Bank of India and Union Bank. There are 2 banks. So the company had taken 2 term loans. Your Lordship, one from Bank of India, one from Union Bank. So, Your Lordship, these are the 2 term loans in respect of which the guarantee was given. But the guarantee was restricted to the value of the residential property.
So, these are the
2 term loans.
Okay.
If there might be others, I'm not aware, but
you are concerned with only this.
These 2, Your Lordship. Yes, Your Lordship.
Yes.
Thereafter, Your Lordship will see on 12th of May 2016, a term loan agreement was recorded, which was a renewal of the existing one, which Your Lordship will find at page 90.
So, what has happened to this letter, consortium?
Your Lordship will find page 90. This is the consortium term loan agreement.
After this is
page
2nd
90.
May. Okay.
Lordship will find inter-se agreement for consortium term loan of 9.25 crores.
Yes.
12th of May 2016. Your Lordship will find Bank of India, Union Bank, and Riga Sugar Company at page 91.
Yes.
Now, Your Lordship may kindly turn to the relevant clause, which Your Lordship will find at page 106 of that agreement. Lordship, at the bottom, column 2, Roman 2.
So here Riga Siga is not a party.
Lordship, it's a consortium agreement between the banks.
So there is not.
Lordship, I stand corrected. Lordship will find the name of Meera Dhanuka at page 106.
106.
Lordship.
Yes.
Lordship, at the end of the table, left hand side, Shri Meera Dhanuka. Personal guarantee. In order to secure her obligations and or liabilities under the guarantee as aforesaid, Meera Dhanuka should create first mortgage and or charge over and in respect of a residential flat number such and such, having super built up, Your Lordship, I am not placing the reason, comprised in plot number such and such, greater challenge, and the guarantee of Meera Dhanuka shall, however, be restricted to the value of her above residential property at New Delhi. So, Your Lordship, again it records that it should be restricted. Now, Your Lordship, may I place the rest of the portion? Provided, however, the guarantee of Meera Dhanuka shall be restricted to the amount of the term loan or value of her residential property at New Delhi, whichever is lower.
Same as this
Lordship.
consortium.
Again, so Lordship, each and every document, Your Lordship, records that my guarantee is restricted to the value of the property. Thereafter, Your Lordship, may I place
Yes.
page 194.
Yes.
This is a declaration by the petitioner. Lordship will find Meera Dhanuka, wife of Sri Om Prakash Dhanuka, residing at such and such, do hereby solemnly declare and say as follows.
Yes.
Lordship, the
Yes.
clause 3, Your Lordship. I say that at the request of Riga Sugar Company Limited, the borrower, as also at my request as one of the guarantors, Bank of India and Union Bank have granted and or agreed to grant to the borrower term loan aggregating to such and such under the facility agreement dated such and such made between the borrower and the Bank of India and Union Bank of India as lenders and BOI acting as the lead bank. And the said lenders also granted and or agreed to grant to the borrower another term loan of rupees 9.25 crores. So Your Lordship will see here both the loans are covered 16.78 as well as 9.25. For modification of the borrower's distillery division as per the instructions of CPCB by setting up a new multi-effect evaporator and biodigester, Your Lordship, such and such, under the facility agreement dated 12 May 2016 made between the borrower and Bank of India and Union Bank of India as the lenders and BOI. As the lead bank and the said term loans shall be secured inter alia by the guarantee of Meera Dhanuka, myself, and in order to secure my obligations and or liabilities under the guarantee, I shall create first mortgage and or charge over in respect of my said flat as aforesaid. Additionally, to secure the term loans provided always that my guarantee as aforesaid shall be restricted to the value of the said flat proposed to be mortgaged in favor of the said lenders.
Yes.
These are all corroborating documents to show that it was always restricted.
Yes.
My Lordship, there was a further revision of the facilities on 27th of February 2017, which has a similar restrictive clause. Lordship may kindly take up page 204. Lordship, this is a sanction of the credit facilities. Page 204, Your Lordship, by Bank of India.
Yes.
Lordship will see referred, it's written to Riga Sugar Company Limited, sanction of your credit facilities with us. Your Lordship may kindly turn over to page 210 directly. Details of guarantors at the very top.
Yes.
210, Your Lordship. Details of guarantors. Personal guarantee of Om Prakash Dhanuka, Srimati Meera Dhanuka, proposed. Restricted to the valuation of residential property at New Delhi, offered as collateral security for term loan 8 and 9.
Where you are reading?
Your Lordship, 210 at the top. Lordship,
Meera
personal
Dhanuka,
guarantee of Meera Dhanuka, restricted to the valuation of the residential property at New Delhi, offered as a collateral security for the term loan of 8 and 9.
Yes.
So Lordship will see that it was only on the representation that my guarantee will only be restricted to that flat that I had made this, entered into such deeds of guarantee. Your Lordship, thereafter, may I place page 222. This is again a deed of guarantee executed between Meera Dhanuka, Bank of India, page 222, Your Lordship. Lordship will find in the matter of guarantee by Meera Dhanuka, this deed of guarantee, Lordship, by Meera Dhanuka. Next page, if Your Lordship kindly turns over to page 223, in favor of Bank of India and Union Bank of India.
Why so much agreement?
Lordship, it's every year the guarantees have to be renewed.
It's a renewal?
Lordship, there are three. Lordship, one of 2015, 16 and 17. This is of 16 that I am placing, Your Lordship. Your Lordship will find the date 223, Your Lordship, clause 1, 12th of May, it's handwritten 2016.
Correct.
So, Your Lordship, I'm showing that even on every renewal, this clause was there. May I take Your Lordship to directly to the clause at page 226. Page 226, clause 3A. May I place it, Your Lordship?
Yeah.
In the event of any default on the part of the borrower in payment or repayment of any of the monies referred to in clause 2 above, or in the event of any default on the part of the borrower to comply with or perform any of the terms, conditions and covenants in the facility agreement and other transaction documents, the guarantor shall upon demand forthwith pay to the lenders without demur all the amounts payable by the borrower under the transaction documents. Any such demand made by the lenders on the guarantor shall be final, conclusive and binding, notwithstanding any difference or any dispute between the lenders and the borrower or arbitration or any other legal proceedings pending before any court, tribunal, arbitrator or any other authority. Now, Your Lordship, provided always, that's there in bold.
Yes.
Provided always the guarantee of the guarantor, being the plaintiff, being the petitioner before Your Lordship, herein contained, shall not at any time exceed the value of a residential property, being a residential flat at such and such. Lordship, the New Delhi flat. Lordship will find the guarantor's New Delhi property.
Yes.
So even the 2016 renewal records this restrictive guarantee, that provided the guarantee of the guarantor shall not at any time, Lordship may kindly mark the words, at any time exceed the value of a residential property. Your Lordship, may I take Your Lordship to the next renewal, page 243.
Yes.
Page 243 is again a deed of guarantee Your Lordship will find. This is 3rd November 2017.
Yes.
So Lordship, at page 2015, 16 and this is 17. Lordship, may I? Lordship, again by Meera Dhanuka. 240.
Yes.
Lordship, with the banks. May I
Which
take
clause
your
you are
Lordship?
what?
246 is the relevant clause, your Lordship. The last clause. Now this deed of guarantee, witness it. Clause 1 at 246, your Lordship. May I place it, your Lordship? If at any time default shall be made by the borrower.
Yes, 247 first two line.
Lordship. Lordship, it starts from 246, bottom last two page, provided as always.
Next.
So, your Lordship, all the deeds of guarantee contain these clause.
Yes.
Now, your Lordship, ultimately, with the consent of the respondents, the premises was sold by way of a deed of conveyance. Your Lordship will see my confirmation of sale letter on page 274. If this is upon me requesting them that I found a buyer, please sell the property so that you can appropriate the money. 7th of January 2020, your letter of intent. This is Kataria Construction is one of the intending buyers.
Yes.
Your letter of intent for purchase of residential flat number 3, plot number W52, Greater Kailash, New Delhi. Your Lordship, this is the same flat that I've been referred to in the name of Srimati Meera Dhanuka at the price of 4 crores. This is the bank writing to the proposed buyer. We request reference to your letter dated 2nd of January 2020 expressing your interest to purchase the residential flat number such and such in the name of Srimati Meera Dhanuka at the price of 4 crores. The said property is mortgaged to the bank as security against the credit facilities availed by the company. Based on the request by the company, it has been approved by the competent authority to dispose of and liquidate the aforesaid mortgage property. So, your Lordship, this letter is a proof that the bank had approved the sale of the property to liquidate it and appropriate it.
Yes.
Lordship, there are the details are given, the demand draft and everything. Your Lordship, I'm not troubling your Lordship with the rest of the details. So the bank gives its consent to sell it. Now your Lordship will find a deed of conveyance. 7th of July 2021. Page 277, your Lordship. So, Lordship, 7th of January 2020, I get the bank approves to sell. I enter into a deed of conveyance in July 2021. Naturally, your Lordship, in between COVID had intervened. Your Lordship will find at page 281 the parties. Your Lordship, this is a registered deed of conveyance. Your Lordship will find the stamp duty at page 277 itself, the stamp duty which has been paid.
Yes.
This is by Meera Dhanuka in favor of Miss Bhavna Kataria. And your Lordship will find the schedule Your Lordship, may I draw your Lordship's attention to page 299 that the money has gone to the banks will be evident from page 299, your Lordship. Your Lordship, there's a box at the very end. Your Lordship will see both favoring, this is the demand drafts, both favoring Bank of India on account of Riga Sugar Company Limited on behalf of the vendor. So the amount has directly been given to the bank.
Yeah.
So, your Lordship, the bank has consented to the sale. The sale has taken place. The money has gone to the bank. And all along, all these documents reflect that the guarantee was always restricted to the value of the residential property. Now, may I show your Lordship my letter asking for NOC from the bank. That's page 317, volume 3, your Lordship. I request for my discharge. Volume 3, page 317. Lordship will see the date of the letter, 6th August 2021. So the deed of conveyance was executed on 7th of July 2021. Almost after a month, I asked for my discharge. This is Meera Dhanuka writing to the MD and CEO of Bank of India. Reference: sale of residential flat number such and such to Bhavna Kataria at the price of 4 crores. Respected sir, please refer to my letter dated 15 July 2021, where I have given all the facts and figures related to my guarantee, where first mortgage and or charge over in respect of my residential flat such and such, which has been sold on 5th of July 2021, and all proceeds has been deposited to your bank as per the sanctioned letter, loan agreement, deed of guarantee, and mortgage documents. My guarantee shall be restricted to the value of my above residential property at New Delhi, offered as collateral security or amount of the term loan granted by the lenders to Riga Sugar Company, whichever is lower. I have not received any reply on the same. I request you once again that I have discharged my liabilities as per the security document by selling the asset and depositing the amount in your favor. Please give the confirmation stating that my guarantee stands cancelled.
Yes.
Lordship, to reply to this, Lordship, the bank, page 325. Is the reply by the bank on 11th of August 2021. Bank of India writes to Meera Dhanuka. So what do they allege? Continuance of the personal guarantee of Meera Dhanuka after the sale of the residential flat.
Yes.
So after everything has happened, when I ask for my discharge, they say, no, your guarantee is continuing. We request reference to your letter dated such and such, wherein you have requested for release of your liability as a personal guarantor in the account of Riga Sugar Company upon sale of the above mentioned residential flat to Ms. Bhavna Kataria at such and such. Kindly note that as per earlier sanctions, your personal guarantee was restricted to value of the above mentioned residential flat. However, as per the latest sanction, that is MCON dated 20th of February 2021, received by the branch, your personal guarantee is stated to be continued even after sale of the above mentioned flat at the price of 4 crores. The same, and your lordship will kindly make note of the date. This is, your lordship, this document has never been brought forward by the respondents, neither in their affidavit in opposition. They have not been able to produce a single scrap of paper to show that my guarantee continued. And your lordship will see the reference of the date of when they are saying when this sanction was revived, was made unrestricted, is 20th of February 2021, whereas your lordship will find 7th of January 2020, the letter that I had shown to your lordship that approved the sale, and 7th of July 2021, your lordship, the property was also sold. So in between, they changed their minds that no, this guarantee cannot be restricted, so it has to be made unrestricted. However, there's no letter disclosing, there's nothing on record to show that, if at all, this sanction was ever there.
Where they got the date 20th February?
Lordship, this is their letter. They've avowed there in their opposition as well, but they have not produced any document to show the same. Your personal guarantee is stated to be continued even after the sale of the above mentioned flat at the price of 4 crores. The same has been conveyed to the company by sanction letter, and thereafter the said matter has been reiterated in the letter such and such and such and such.
So if your property has been sold it out and realized the amount,
Lordship.
So what further remains with you?
Lordship, that's what I am saying. Lordship, I have discharged my obligations under the guarantee. I am seeking a discharge. All the deeds of guarantee show that my guarantee is restricted to the value of the residential flat. That I had taken consent. They had in writing given that the competent authority has approved the sale.
What was the valuation given at the time of mortgaging the property as security?
Lordship kindly takes up. Page 22.
What was the amount? 22.
Lordship.
Where is the valuation?
Your Lordship will find at page 28. Lordship will find the date of the valuation, 14th May 2015, page 28. In view of the above, the fair market value, realizable value, circle rate, vis-a-vis the insurance of the property are assessed at 697.5. That is the fair market value. Realizable value at 558 and circle rate at 333. And insurance value is 29.23.
So as per the value, assess 697, 6 crore 97.
Lordship, that's the fair market value. The realizable value is 558.
558, and it was
sold at 4 crores.
It was
Lordship,
advertised.
Lordship will
Auction.
find the consent letter.
How it was sold?
Lordship, may I just place the consent letter, confirmation letter 274, volume 2. Lordship, this is the bank writing to the proposed buyer, proposed purchaser.
Yes.
We request reference to your letter dated such and such expressing your interest to purchase the residential flat and such. The said property is mortgaged to the bank security against the credit facilities availed by Riga Sugar Company promoted by OP Dhanuka. Based on the request by the company, it has been approved by the competent authority to dispose of and liquidate the aforesaid mortgage property by following the Swiss challenge method. So, Lordship, it so seems that the company had found the buyer for the bank and the bank had agreed to liquidate the same.
Yes, then
Your Lordship will kindly may I place the entirety of the letter since this is fallen from your Lordship. Based on the request of the company, it has been approved by the competent authority to dispose of and liquidate the aforesaid mortgage property by following the Swiss challenge method. Against the said backdrop, we would like to inform you the following course of action to be adopted. The paper publication that your Lordship was contemplating. Demand draft in the name of Bank of India of minimum 10 lakhs needs to be deposited or remitted by you to the bank as token amount with copies of the KYC documents of the company and the directors of the said company. Thereafter, bank shall make a paper publication seeking bids for the aforementioned property within a period of 30 days from the date of publication. And your Lordship, this is a letter by the bank. In case the bank receives any bid or purchase offer greater than the price of 4 crores as quoted by you, then you shall be given the opportunity to match the said offer. In case you fail to do so, the property will be sold to the highest bidder and the token amount of 10 lakhs will be refunded to you by the bank. So, your Lordship, the query that has fallen from your Lordship is answered in the letter in itself that the bank had stated that in case they get a better offer.
What has happened?
Lordship, that I guess my learned friend will be able to say because I have this on letter, this on record. Whether the bank has made an advertisement or not is on the bank because this, your Lordship, we have.
What is their contents?
Lordship, they are saying that the guarantee is not restricted. May I take your Lordship through their affidavit in opposition? Your Lordship, may kindly take up page 5 of their affidavit in opposition.
Yeah.
Lordship, may I start with I? This is their contention.
Yes.
The petitioner irrevocably and unconditionally guaranteed the due repayment by the borrower, that is Riga Sugar Company Limited, and the petitioner had further irrevocably and unconditionally guaranteed and undertook to pay the respondent number 1 within 2 days from the date of demand, all and every sum and sums of money which shall be owing by the said Riga Sugar Company. However, your Lordship, my contention is I've denied it in my reply because the documents speak otherwise. The guarantee provided by the petitioner shall be continuing guarantee for the purpose of securing the whole of the monies mentioned in clause 1 hereof, which your Lordship in their own opposition they state subject to the aggregate principal amount under the said credit facilities not exceeding 6 crore 94 lakhs together with all interest thereon or on such presently at. So, Your Lordship, they also say this, they also rely on clause 1 and say this is restricted to 6.94 crores. Now, Your Lordship may kindly take
6.94.
Lordship.
Your property sold at 4 crore.
Lordship will kindly take the subsequent deeds which says whichever is lower.
Yes.
Your Lordship may kindly take up page 6. Lordship, I believe this is I. In the middle of the page. It appears from the above and from the perusal of the contents and or obligations prescribed under the said deed of guarantee that the respondent number 1 has the unfettered right to proceed against the petitioner, and under no circumstances the guarantee was deemed to be restricted in many manner whatsoever as per the latest sanction letter. But they do not annex the latest sanction letter. They do not come up with any document, even a scrap of paper, to show that the guarantee was not restricted.
Yes.
Now, Your Lordship, Lordship may kindly take up page 7, paragraph L. In any event, contrary to the allegations of the petitioner herein, the deed of guarantee never contained any term by which the extent of guarantee was restricted by the value of the property in question. So, this is absolutely contrary to the terms and conditions of the deeds of guarantee. The said deed of guarantee merely contains a figure which was arrived at to indicate the liability of the principal debtor. As such, there arises no question of dischargement or release of the guarantee of the petitioner. Lordship, subject to what falls from Your Lordship, the averments in the opposition are completely contrary to the documents on record.
Yes.
Lordship, those are my submissions. I am being led by Mr. Chaudhary. I was hoping he would reach to conclude. But Your Lordship.
Next, anything further?
Lordship, those are my submissions. If Your Lordship may kindly grant Mr. Chaudhary 5 minutes to conclude, because I have placed my argument according to my own self, in case Mr. Chaudhary wants to add anything else. And then they can reply, Your Lordship. If Your Lordship
Yes,
would.
why? You are for the bank.
Yes, yes.
Why?
I'll show my lord the documents. We never really heard of any guarantee. My lord, as a matter of fact, your lordship would be surprised to know that the principal borrower, your lordship has seen the quantum of, my lord, the amount which has been given by the bank. My lord, they got a friendly creditor to invoke a section 7 and take it to NCLT. I don't know what has happened in NCLT after that. My lord, so much of money of the bank will just go up. And I will show the documents from affidavit in opposition does not discharge the guarantee. And I will rely on a decision of my lord, Lord Denning, Court of Appeal. But this letter cannot be construed as discharge of guarantee. If your lordship so wants, I can start. And my lord, the plaint, I would show what they are seeking for in this injunction. First of all, is to restrain me from invoking surfacing against the borrower. That cannot be barred. That is expressly barred under section 34 of the Surfacy Act. Your lordship is aware of that. What they are seeking for here is mandatory injunction from your lordship saying that the guarantor has been discharged. Well, this kind of mandatory injunction cannot be granted at an interlocutory stage. That is what they are seeking for today before your lordship is the main relief in the suit. They are seeking for a decree in this interlocutory application. I can demonstrate that, but I would like Mr. Chaudhary to finish so that I can address.
Next day, 5 minutes. I do not think Mr. Chaudhary is anything else. Just one.
The lordship so desires, I can start my arguments.
This one submission that Mr. Bhattacharya has made, your lordship, that we are not obstructing to Surfacy. There's, in fact, subject to what falls from your lordship, there's nothing left in Surfacy. The flat has been sold. For Surfacy, there has to be a secured asset. That asset has already been sold by the bank.
That is the intention.
Your lordship, there's no order restraining them from proceeding in Surfacy. They are free to proceed. If the secured asset itself has been sold, there's no question of proceeding in Surfacy today.
And the company is in NCLT. I don't know what is the status of the NCLT proceedings. It is there in their petition, my lord. A friendly creditor not any financial corporation.
What the bank has taken any action against the company?
But it is already in NCLT.
Participated.
We have participated.
You made your claim there.
Yes, yes, we have lodged our claim.
Bank has made a claim before the NCLT.
Oh, I'm sorry, my lord. My instructions are that bank has proceeded in DRT.
DRT.
Yes.
Against him.
Against the company, Riga.
Correct. Against
And also the borrowers.
Whether no initiated any proceeding has been initiated against this plaintiff.
Against the plaintiff. Oh, they are parties. The guarantor is also a party.
Where is the?
Wait, that's it. My lord, right now we don't have the OA. If your lordship so directs, I can get a copy of the OA.
You not disclose anything to that effect. In the
If your lordship
affidavit.
wants, I can one-page affidavit, my lord. By way of
Page, if he is the party before the, that's why, because that's why
they are also aware.
That's why I put the two question to him with regard to what was the loan of the company and what the security. Security, the loan, the value has been shown 6 point something crore.
Yes.
Correct, and loan is something else. But your bank has, with regard to the agreement, time to time which the agreement is extended, you are restricted to the value of the property only.
My lord will kindly see those letters. I will show my lord those letters. That is not restricted. It was a counter proposal, which has to be accepted by them.
The agreement.
But I will show that the first agreement to the last agreement.
The Chaudhary complete.
When he will be available. We were supposed to.
Problem. You persons are not completing the argument again. All matters.
Lordship keeps it in the list. Lordship, Mr. I do not think will take more than 5 minutes.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Plaintiff has filed an application being GA1 of 2022, praying for interim order. Police counsel for the plaintiff has argued at length and prayed for time to make further argument. In view of the submission made by the counsel for the plaintiff, which is adjourned, let the matter appear on 20 August.
28th?
2020.
Lordship, the interim order may continue. It's expiring today.
Interim order is there?
Yes, your Lordship.
Interim order, which is going to be expired today, is extended till 23rd of August 2024 or until further order, whichever is available. Yes, call the list.
Conditional plaint, item number 20.
I'm for the plaintiff, Miller.
Yes.
In the instance suit, Miller, the plaintiff have lent an advance and intercorporate loan, Miller, to the defendant, Miller. Miller, if sees, Miller, the entire cause of action as pleaded in paragraph number 16 of the plaint, Miller, at page 7, Miller.
When the loan obtained?
Miller?
When the loan obtained?
Obtained in 2019, Miller, and time to time they have made payment, Miller. Miller,
the last payment was made.
The last payment was made on, Miller. Interest. March 2021, Miller. The interest part, Miller. If my lord sees.
Last payment was made on?
March 2021, Miller.
Where it is?
Miller, that is in form of TDS, Miller, the interest part, Miller. If my lord sees page 19, Miller.
19?
Yes, Miller. At form 26 AS, Miller. Yes, Miller. Thereafter, Miller, the defendant failed and neglected to make payment, Miller. We sent a notice, Miller, which is at page 35, Miller. The demand notice. They never replied, Miller, to this notice, Miller. Thereafter, Miller, we have taken steps. Thereafter, Miller, we have taken steps, Miller, as per 12 Web Commercial Codes Act, Miller. And the non-starter report is at page, Miller, 64. that despite service final notice to the opposite party, they did not turn up for the mediation process, my lord.
What is the total amount?
Well,
So how the consumer and the commercial?
That is an intercorporate corporate loan, my lord, given to the defendant, my lord, by the plaintiffs.
Maybe.
Yes.
How the commercial?
My lord, the defendant sought that loan, my lord, for the purpose of infusion of the same into their business, my lord.
Maybe they have taken the loan for their business, but it is not a transaction between you and for the purpose of the business. He has taken the loan for the purpose of the business, but this is not in between you and the defendant for the transaction of the for the purpose of the business.
No, but my lord, they have infused the same into their own business.
Maybe.
Yes, and the interest rate was also agreed, my lord.
Maybe. But what is the transaction between you? You have simply lent the amount to the defendant, and defendant has taken for the purpose of his business. So where is the connection with you and the defendant with regard to the commercial business?
That is a thing, my lord. If
think it,
if my lord pleases, then my lord may kindly direct it to go to the non-commercial. If my lord pleases, my lord.
You think it?
I have no problem, my lord. If
problem. There is an agreement.
Yes, my lord. There was.
Where is an agreement?
That oral agreement was there. That is pleaded at page 4, my lord. Sorry, page 3, para 4, my lord.
That's what I'm telling. Lent in advance for accommodation loan.
Yes.
So what do you want?
Well, clause 12 leave, my lord. Since my lord, if my lord comes to
no, but how is in the commercial code?
My lord, may then be transferred, my lord.
Then transfer it cannot be. Commercial to original it can't be transfer. Original to the commercial it can be transfer. You can withdraw it, file a press, the court fee can refund and use that. That liberty can be given to you. Or you take instruction. You
My lord, may I take instruction?
Take instruction. Come on Friday or Monday.
Tuesday, my lord.
Tuesday. As per the prayer made by the counsel for the plaintiff, let the matter appear on 20th August under the same heading.
21.
Yes.
Your Lordships, I appear for the plaintiff. I seek leave under clause 12 of the patent, latest patent, Your Lordship. Mediation has failed, Your Lordship, and non-starter report is at
Why it is commercial?
So it's commercial because it's dealing with carriage of goods and ordering transaction of merchants. Your Lordship, the defendant had requested the plaintiff for carriage of goods in their containers, Your Lordship. So the containers are detained from Kolkata to St. George's, Grenada. The containers are now detained in St. George's. Your Lordship, in
the last payment was made.
Your Lordship, the paras dealing with the contract is from 5 to 8.
Correct, that you gone through. But with regard to the when the last payment was made.
Seeking dispensation with clause 12, I have with the details in spare.
Yes, Your Lordship, mediation is concluded. There's a non-starter report in page 73. I'm just seeking leave under clause.
That's correct.
Yes.
I want to know when the last payment was made, when the cause of action arose, when they have refused to pay the further amount.
So, 2023.
When? Where? Which paragraph?
Sir, in my lord, you're in para 8. A copy of the non-starter report. You will.
2020. Yes.
Your
Where
Lordship
is the
also
non-starter report?
in page 73. Your Lordship also in.
Yes, got it. Why clause 12?
Your Lordship, the petitioner is within the jurisdiction and part cause of action is also within the jurisdiction, Your Lordship. Contract was made in within the jurisdiction.
Leave granted.
Grateful, Your
Admitted
Lordship.
subject. Next.
Grateful, Your Lordship.
Number 22.
Well, this is my application which had come before your lordship yesterday, my lord, when the other side had appeared, and they said that they don't have money in their bank account because there was an injunction restraining them from my lord, using the bank account other than without keeping aside a sum of rupees.
Yes, very.
Well, this is their tendency, my lord. They in the last orders, my lord, which I had shown it to your lordship, my lord, in the proceedings before the ABP. My lord, this is the my learned friend
This
is
is the
here.
tendency, my lord.
But this is not the tendency. The tendency is to play hide and seek. Now the thing is that your lordship, my lord, on the my lord, yesterday, I directed my learned friend, my lord, to give documents to show, my lord, that they had complied, to prove that the defendant has complied the interim order by keeping aside the amount mentioned in the order dated 19 July 2024.
Correct.
Now, no affidavits.
Yes.
My lord, on previous occasion, my learned friend entered appearance and my lord requested before your lordship, my lord, and prayed before your lordship that my lord seek for certain time because my lord, my clients are my lord out of station and therefore my lord, they could not affirm it. It was fallen from your lordship that my lord, we have to prove whether the my lord, the interim order already been passed, my lord, whether that has been complied with or not. This is an injunction restraining us from operating a bank account.
Correct.
I am putting question to myself. How can I prove it that, my lord, the injunction which has already been passed against us has been complied with?
Okay.
It is up to them, my lord. It is up to them.
Sensation suffering for the plaintiff, sensation suffering for the defendant. By an order dated 19 July 2024, this court has granted time to the defendant to file affidavit in opposition, but till date no opposition is filed. The matter was listed yesterday, that is on 12th. On that day, the learned counsel appearing for the defendant has prayed before this court and prays for a day's time to ensure that the defendant has complied with the order, interim order passed by this court. Accordingly, the case is adjourned till today. Today, when the matter was called, another advocate has appeared before this court and questioning before this court how the defendant can produce the document to show that the interim order has been complied with. In view of the submission made by the counsel for the defendant, chance to file affidavit in opposition is closed. Hearing. Start.
My lord, if your lordship, my lord, kindly comes to, my lord, the
changing of advocate will not change the law.
My lord, kindly appreciate on previous occasion I entered appearance.
Maybe yesterday your junior has stated that and they have a document. A daytime will be given, they will produce. Now changing the advocate will change.
My lord, it is not the fact. My lord, kindly appreciate. My lord, kindly appreciate. Perhaps, my lord, I could not, my lord, make your lordship, my lord, understand. It is my failure that, my lord, yesterday, my lord, in this simplicity, he short time.
That's why he has short
My lord,
time.
it was fallen.
Put the question to your junior or your colleague, whatever it may be, whether you have complied with. He told that, yes, I will take the document from the funds. That's why I recorded this the order. It is not the court so much has passed an order.
So, my lord,
ask your colleague.
My lord, I have not been posted with the facts, my lord, but the fact remains, my lord, if there is any communication gap, I am extremely sorry for the inconvenience caused.
Before making the submission, please communication may be clear before outside of the court and make a submission before this court.
My lord, I have been informed by my learned junior that the my lord, he has prayed before the time, and so that my lord, your lordship will accommodate. In the meantime, the my lord, the opposition would be filed, and it was fallen from your lordship.
I had proceeded with the matter yesterday, and I had pressed for an order. Because
yesterday he has asked for the time. I am not telling that he has not asked for, and the court has only because the other side is asking that the receiver should be appointed.
No, I didn't want a receiver. I wanted a security.
Security is to be given. Then this court has gone through the earlier order. Then put a question to your colleague whether the interim order has been complied with. Keeping aside that if it has been keeping aside, question of security does not arise.
My lord, the few bank accounts are there which has been already been mentioned. My lord, the question of operating does not arise, and even the amount which has been mentioned over there is not lying. So far, my lord, I have been informed.
If it's not lying, then security has
to be put in. It's an unimpeachable claim.
So, my lord, in that event, my lord, so far
Very
as
well.
my lord, the question of security comes in a later stage, my lord. Prior to that, my lord, they have to satisfy whether this, my lord, the application is maintainable or not. Only, my lord, the simplicity I am seeking for a time, my lord, 7 days time, so that we can file the opposition.
But in the meantime, let them put in security. At least the unimpeachable claim which is at, since he says that the money is not there, that makes it suffices further, my lord, that I'm entitled to an order of security.
Because this is nothing but a money claim. Since it is a money claim, my lord, he is seeking for a my lord judgment.
This court is not going into that merit. This court is going into the merit. What ask your
so I have
colleague,
to take instruction. I have to take instruction.
What
with
instruction?
That whether, my lord, they have operated in how because, my lord, they are having proof. They are, my lord, insisting upon a security. The insisting upon a security comes if they do have document that I have operated the bank account.
No, of course not.
It is the burden lies upon them.
I am entitled to a security and order 38 rule 5.
The court has no power to ask the party.
Certain, but then I have to take instruction.
So that's why what the court is telling since beginning. Your colleague has taken a day's time to bring the record that they have secured the amount.
Lord, he sought for 3
Kindly
days.
see the order.
Yes.
You're not downloaded the order. It was uploaded yesterday evening itself.
My lord, only the difficulty is this, my lord, he placed before your lordship, my lord, I have been informed by him that, my lord, his client are out of station. He is not in a position to take 3 days time has been sought for. It is lordship's pleasure that, my lord, granted 1 day time so that, my lord, that can be produced.
He has not asked that. We are not. I will show the recording. I will show the recording. He asked 1 day time. And you cannot change the argument, sir.
And he has specifically said
that you cannot change the argument time to time. Since starting your business argument, you started some argument other what your junior has argued or your colleague has argued yesterday.
My lord, perhaps your lordship is correct, my lord. I am extremely sorry for the inconvenience caused, but the fact remains, my lord, time may kindly be granted so that I can take instruction. Kindly give time and post the matter on Monday. In that event, I would be able to apprise your lordship, my lord.
Yesterday, your junior has appeared and
so I'm extremely sorry inconvenience caused. Whatever might be the submission of my learned
for extending the time of filing the affidavit, only the court has put the question because the other side is pressing the application for security deposit. That's why I put the question to your colleague. Yes, please take the instruction whether the amount has been secured or not.
No, my lord, the injunction whether we have operated the bank account or not.
Not operated. No. Kindly see the order that amount is
kept aside the sum of
or not. What is the order? To kept aside that amount in the account. Whether that you kept aside or not. That is the only question.
My lord, in that event, my lord, on that day when the application has been moved, they have to say before this court by giving an affidavit that on that day, my lord, the amount was there.
That is
the issue of keeping aside, my lord, comes if the amount is there.
So you could have been argued that matter.
If they, my lord, I take it that the amount is not there.
Keeping
if
aside
the amount
comes,
is
not the amount is there.
When you receive the notice. When you receive
that was my first point, my lord. Initially, the notice was not.
You tell me the code.
On previous occasion, when I entered appearance. Yes, I have submitted before your lordship.
You had the order. You had the order.
My lord.
Of the interim order.
My lord.
It was communicated to
my
you.
Lord.
You had the order.
On previous occasion.
You have not submitted before this court. My lord, you have passed an order. There is no amount is lying in the account.
My lord, on the first day, my lord, my submission was that, my lord, the first day the notice was the summon was not served upon me. Only few documents has been served that does not contain the injunction application. So, my lord, it was fallen from your lordships on that day. My lord, kindly see on previous occasions order.
This practice, this court is not allowing any time. So many advocates are appearing. This court is taking lenient with all advocates, but this type of the advocate coming once junior, taking some order, second day senior is coming for making some submission. Other than
this is before your lordship, my lord. This is not my practice, my lord. Kindly appreciate.
You had
I am not the novice in the profession, my lord.
It is you have done today.
My lord, only the thing is this: there is a communication gap. My lord, this
what
is
the communication? Once you are appearing with your colleague, and he has appeared, you are not you don't know what he has stated before court on the last occasion.
Look, since my learned friend now says that this amount is not lying in their
I have to take instruction. I have to take instruction.
My learned friend has said it's not there. His colleague also on the last occasion had said that this amount is not there in the bank. And in that event, my lord, if it's not there in the bank and they are incapable of securing, your lordship would pass an order in terms of
the matter has been moved.
Your lordship will pass an order in terms. pass an order in terms of
which is not there on the relevant.
I was not supposed to know. I had taken a very lenient order, in fact.
It is the party who has given the details of the account. This court has passed an order. You got the order. If you got the order, this is the third time you are appearing.
No, this is the second time. I am
Third time.
appearing.
Third time. Today is the third date.
Third time. You had appeared on the first day.
Last
Today
occasion
again you have
appeared.
appeared.
Then yesterday your junior has
You have taken
appeared.
time
Now
for
today
all
is the third day.
affidavits.
This is the second time, my lord, he is appearing. You kindly see the order.
19,
Yesterday,
19 July. 19 July you had appeared. What is your good name?
Subhabrata Datta, my lord.
What is the 19 July? This order is also wrong. 19 July order is not correct.
Yes, my lord. Including, my lord, the yesterday, that would be the third day, my lord.
Well, all the orders against ABP Anando, where the execution, then the terms of settlement, everything where they have defaulted, my learned friend had appeared on instructions.
My lord, the APB Anando's case is not here, my lord.
Yes, it is. Because you're a regular defaulter, that's why it's here.
My lord, since I am a regular defaulter, this issue was there before the arbitral tribunal, and subsequently, where, my lord, they did not fetch any order and subsequently approached before this court.
Of course, I had to.
Yes, what is the case?
Yes, my lord. My lord, since my learned friend, my lord, has on instruction says, my lord, that no money is lying, and now, my lord, if your lordship sees, my lord, the amount claimed, my lord, is 6 crores and odd, and your lordship sees, my lord, comes to page 140. My lord, their financial situation, my lord.
Yes.
3 checks, 1 crore 50, 72 lakhs, and 1 crore 83, all dishonored. On 3rd December 2019, on 31st March 2020, and also, my lord, on 10th and on, my lord, 31st December 2019. Thereafter, my lord, your lordship kindly comes to, my lord,
Yes.
page 145. The reasons for dishonor. It's insufficient funds. Now, my lord, your lordship sees. Now, your lordship sees, my lord, page 153. There is a confirmation of accounts. Comes to page 165.
153.
Well, at 165.
Yes.
Let your lordship sees, my lord, 4 crore 2579 was the outstanding closing balance. And then, my lord, there is an opening difference of 57,190. Other than that, it's a confirmed amount.
The confirmation of account?
Yes.
Signed by both the parties?
Yes.
Closing balance is?
My lord, 4 crore 25.
Yes.
And other than that, 57,190. Then your lordship sees the the mails that they have sent, the correspondences.
Yes.
Well, at page 167, the continuing mail from page 166.
Yes.
Well, at page 167, kindly note that the amount outstanding up to July 19 billing will be cleared by 28th October 2019, and the amount outstanding up to August 2019 billing will be cleared by 15 November 2019. Nothing paid thereafter. My lord, thereafter, my lord, other proceedings which are also there. My lord, 168, your lordship kindly comes.
168.
8, my lord.
Yes.
Your lordship sees from Signet to Dibyendu Lahiri. Below, please find the tentative payment schedule. We will pay rupees 80 lakh either on 10th or 11th September. For the rest of the month, we will keep on paying various amount depending on the availability. Within the first week of October 2019, we will pay. Within 15th October 2019, we will pay. Then your lordship, my lord, kindly comes to, my lord, the orders which I had placed, my lord, against ABP Anando, which clearly shows, my lord, that they have been a regular defaulter. Not only a regular defaulter, my lord, they have breached the orders of court and the terms of settlement, which was entered into by and between them. My lord, your lordship kindly comes from page 187 onwards. 187.
This was entered between?
My lord, between ABP Private Limited, that is Anandobajar, and Signet, that is there.
Other parts.
Yes. Breached the order of the terms of settlement. My lord, your lordship sees at page 187, he files a terms of settlement signed by the parties and their respective advocate on record. Turns over to page, my lord, 188. Since the decree remains satisfied, there will be an order in terms of page G of the column of the tabular statement. Then, my lord, your comes to 192. They were directed to file their affidavit of assets. They did not. Warrant of arrest was issued. They appeared before the court. The lordship turns to, my lord, page 194. My lord, this is their regular delaying proceeding. That's their tactics. Kindly comes to 194. In the meantime, the judgment debtor is directed to make necessary payments. It is made clear that the direction for filing affidavit of assets is peremptory. Then, my lord, your lordship comes to, my lord, straightway to page 197. They give their affidavit of assets.
That you already pointed out.
Yes. Now, my lord, your lordship, my lord, there are other cases also which are pending. Kindly comes to page 253 onwards.
Yes.
But 138 cases. Then, my lord, your lordship sees case status. Vidhannagar Court, respondent is Signet, year 2023, filed by Bennett Coleman against Signet. Then, your lordship kindly comes to page 255, filed by us. Then, your lordship, my lord, 258, Bajaj Finance against them. Turns to 259 against under section 418, 420, 406, 506, 120B.
Yes.
Then again, it's our case. Then your lordship kindly comes to page 263. IIFL Finance files a case against Signet, against section 420 and all those. Then your lordship comes to 265. ICICI Bank files it against them. And then 266, my lord, a private party has also filed against them.
Yes.
Now your lordship kindly sees what they do is, your lordship comes to page 267, which they had pointed out. My lord, properties have been purchased, which is at page 273, since 2021. Which clearly shows, my lord, they had the money, but they have not paid and they have siphoned it off and purchased properties. Page 273.
Yes.
Your lordship sees our my lord, admission was 2019, they are going to make payment. 2021, they purchased properties in Southern Avenue. And what I have to show in an order 38 rule 5, my lord, is not a decree, but just an unimpeachable claim. That's all.
That's all.
I am only praying for an order, my lord. Now, since they say that they don't have money, your lordship would pass an order in terms of prayer A.
No.
That is an injunction restraining them from, my lord, selling off or alienating their 3 properties.
Yes.
But I think that, my lord, your lordship is annoyed too much, and therefore your lordship.
No, not annoyed.
My lord, kindly
I
take
don't
the
allow this practice. That's why you want to argue the matter.
My lord,
This
kindly have a
practice,
look.
this court avoids. Once the junior is coming, second day senior is coming, third day. This practice, this court is giving equal treatment to either senior or
No, I am
junior.
obliged. I am really obliged, my lord. I am extremely sorry for the inconvenience.
But
My lord, kindly
the
take
conduct, if the senior is coming and running, this was not stated by the junior and this was that.
I am extremely
Yes,
sorry. For
what
this.
is your case?
My lord, kindly see, my lord, the order dated 19th of July 2024.
Yes.
My lord, kindly see my name is appearing, my lord. The counsel of the plaintiff files an affidavit of service and let the same be kept with the record. The counsel of the plaintiff submits that the defendant has only received the copy of the plaint, but has not received the copy of the application of the annexure thereto. It was my submission. Considering the submission made by the counsel for the respective parties and the learned counsel for the plaintiff is directed to serve the copy of the application along with the document to the learned counsel for the defendant in course of the day. Counsel for the plaintiff prays for the extension of the time interim order dated 14th of June 2024, which was subsequently corrected by an order dated 24th of June 2024. Counsel defendant prays for time for the affidavit in opposition. Let the opposition be filed within 2 weeks. This is my first appearance. Prior to that, there was no appearance.
Yes.
The next order was passed yesterday. This is the second order.
Yes.
My learned junior entered appearance. My name was not there. The counsel for the defendant prays for the extension of the time to file the affidavit in opposition on the ground that the defendant is out of station.
Correct.
The counsel for the plaintiff raised the objection and submitted that his court has passed an ad interim order, but the defendant has not complied with the said order, keeping the amount aside in their amount. So, my lord, this is the yesterday, my lord, the second time we entered appearance, sought for time. In first occasion, my lord, since there was no document and the pleading, everything has not been communicated to us, therefore we sought for time. Secondly, my lord, yesterday I sought for time, but this is the second time. Today I am appearing for the third time. This is an application for injunction. And, my lord, your lordship was pleased and kind enough to reject, to file our, my lord, objection to the my lord, their injunction application. Only on the ground that today also we are not in a, my lord, they come with a clean hand, or, my lord, we do not produce any document to that effect. My lord, so far as the, my lord, order 39 rule 5 is concerned, my lord, it is a very draconian provision by dint of which, while, my lord, the court will consider to allow an application, certain basic principles which are required to be considered is there to consider in a, my lord, stricto sensu. In my, my lord, the application of the injunction application, my lord, what has been already stated, I did not find out single averment whether I am, my lord, selling out my property, whether, my lord, only kindly see, my lord, and which does not contain any material particulars that we will place one by one. My lord, kindly see.
In that, I am showing the document to save the time of the court. Give the answer to that. Come to the page 273.
Page 73.
273. 273.
The volume to the two volume.
This is the two deeds. If there is an amount paying to the other party, instead of paying the amount, you are registering as purchasing a deed, that is not a siphoning. Tell me. Leave aside other things.
I have to take instruction.
Then you have taken July, you have taken. So you have started the argument 38 rule 5 does not complied with. This court is very well aware of the every day I am dealing one of the matter of the order 38 rule 5. Correct. And the court has passed the court has passed an injunction not only on the basis of the prima facie, on the basis of the record. So this record is with you. So whether it is not a siphoning off, tell me. If it is not a siphoning off, then
with humility, my lord, I am submitting. I have to ascertain from the, my lord, my client. And
the public document. What
right now I am not in a position to give reply without taking, my lord, taking instruction.
This is the sir, you have taken the record. This court has passed an order to supply you 19 because yesterday it is not your prayer, or today also that is not your prayer. The document has not been received. You have received the document.
It was my submission on 19th.
That's what I'm telling. On that day you have received the copy.
Yes.
So today we are on August.
Yes.
Correct. So this document is in file 273.
My lord.
So whether you are not
so,
taken...
my lord, my learned junior has specifically submitted since they are out of station due to, my lord, the medical, my lord, the emergency, and therefore we are not in a position to take instruction.
Okay. Then next.
So, my lord, so far as the ascertaining, my lord, the veracity of the document, I have to take instruction. So far as, my lord, the purchasing of the property, in my understand, in my, kindly appreciate.
273, 274, you wanted to take the veracity. This is a public document.
My lord, in one of the ground.
Even will go by the new act also, whether you have to, this has to be proved as per the IT Act.
My lord, under what circumstances they have purchased, it is not the, my lord, sacrosanct that, my lord,
question of circumstance does not arise once it is before the court that you are siphoning off. There is a The specific document is
this
before
is
the court. The question of circumstances does not arise.
May I be permitted to place? This is nothing but a document on the basis of which it can be inferred two properties has been purchased.
Correct.
Purchasing a property, my lord, in anywhere in any of the ground under Order 39 Rule 5.
Okay, that's what I'm telling you. I will record your submission and the court will decide. Leaving aside the loan amount, you are purchasing the property. That is not a siphoning of the amount. That is not a siphoning of the amount. So that's why I'm telling you, purchasing the property, you deposit the security amount and you take whatever the time you file your affidavit. There is no problem if you are purchasing the property.
Milord, since Milord, there is an injunctional order, if anything would be there in the account itself, in that event, by Milord, by dint of the injunctional order, I have been already been restrained. If anything would be there, that is there, I cannot withdraw any amount. So their interest is protected.
That's why I wanted to show. Then yesterday your junior told me this. He has produced the document. Today you are telling that there is no amount. So automatically from your submission it shows that you have violated the order.
So, Milord, if this only the thing is this, there is an injunctional order, so that I would not be permitted to operate the bank account. If I operate the bank account, my obligation would be.
That's why the court has simply passed an order to produce the document to show that you comply with the order. You not produce the document. You comply with the interim order. You are telling that the interim order there is no necessity for production of the document.
No, this is an injunctional order whether I have operated the bank account or not.
No, operated no. Keeping aside the amount, whether you have kept.
If the amount would not be there, the issue of keeping aside does not arise.
So you are not mentioned before this court. 3 dates you have appeared before this court.
It is not the 3 date, only the single.
Your lordship is a larger than judgment. 40 and 41.
Okay.
42.7. And this pleading was there in my petition. Today he comes up and says, without filing any opposition, that I don't know, I have to take instructions. So this affidavit in opposition is also not ready.
Yes, anything further?
Yes, Milord, I want to place it, Milord. This entirety, so far as the Milord, the application is concerned.
So suffering for the plaintiff, so suffering for the defendant. उसमें तक देना close ना the counsel for the plaintiff has argued concluded his argument with respect of GS2 of 2024. So the counsel for the defendant has argued that due to paucity of time argument could not be completed. Fix Friday. What is the date? On not Friday. Fixed on 20th August 2022 at the top as parted.
Well, 20th I'm in a little different. 20th I'm in a little difficulty.
So then 23rd or 19th. 23rd.
Well, 19th is okay.
19th at the top. At the top as parted. Interim order which is going to expire today is extended till 23rd of August 2024 or until.
Make it Tuesday, Milord.
I'm not there on
Tuesday. I fix that, but he's having difficulty. Then I am fixing on 23rd. 23rd and interim order is extended till 27 or until 27 or until further.
Milord, may I be permitted in the meantime to file a opposition if your lordship permits?
My lord, item number 19. My lord, the interim order is expiring today. It was fixed at 3 p.m.
19. Who is for the other side?
43.
Who's for the other side?
He was appearing, but today he has not appeared.
With order. So suffering for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff submits that interim order granted earlier is expiring today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 24th of September.
The interim order is also expiring.
Or until further order, whichever is earlier.
Item 39.
Makes it returnable on any day.
24 September.
Interim order is expiring today. Lordship will look at.
But fixed on any day. At any
July. I am mentioning on notice. The email is also there. Mr. Shen.
Item number 39.
Yes, item number 39.
Item number 13.
Interim order till 13. That's the reason I have checked up this time. I'm waiting from the moment. Could not be taken up, Milord. No difficulty.
Who is for the defendant?
Mr. Subhashish Sengupta, I am giving him notice. I am giving him notice. Milord, email is there.
For the plaintiff, praise for submit that interim order granted earlier is going to be expired on
today, Milord. Today. That's the reason I mentioned
today
13.
and paid for extension of interim order.
Any date
The
convenient,
submission
any
made by
day.
the counsel for the plaintiff. Interim order granted earlier is extended till 27th of September 2024. This is the matter on 24th of September.
With regard to item number 36.
Same, Milord, with item number 26, Milord.
Who is for the other side? 26. Who is for the other side?
26. Milord, this was moved, Milord. I don't know who was, Milord, who has appeared.
So appearing for the plaintiff, for the defendant, for the plaintiff submitted.
Still 30.
They expire today and paid for extension.
My learned friend is there on the other side, Milord.
All give the name, give the name.
He's here.
Appearing for the defendant. Sponsored for the plaintiff submitted. The interim order granted is going to be expired today and paid for extension of the interim order. In view of the submission, the counsel for the plaintiff, interim order granted is extended till
Any date, Milord. My learned friend is here, Milord.
Till 30th of September 2024. This is the matter on 27th of September.
Grateful. Much obliged.
With regard to item number 36, I'm mentioning upon notice, the interim order is still today.
36.
In this matter, I am for the defendant, Your Lordship. Your Lordship, only one prayer, Your Lordship. Time to file the affidavit in opposition be extended for 1 week at least.
Suffering for the plaintiff, suffering for the defendant, counsel for the plaintiff, praise for extension of the interim order, which is going to be expired today. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended.
Time be also extended accordingly.
Counsel for the defendant, praise for extension of last line. Counsel for defendant, praise for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
1 week, 1 week at
It has
least.
already taken 3 weeks.
Within 1 week,
One
we
week.
reply if any there to file
1 week
within a week
thereafter.
thereafter. List the matter on 17th of September 2024. Full stop. Interim order granted earlier is extended till 20th of September 2024.
I'm grateful, Your Lordship.
Lordship, kindly leave to mention item number 32, Your Lordship of the commercial list. Only difficulty is, Your Lordship, the interim order is expiring today.
Give the order.
Yes, Your Lordship.
32.
32.
Suffering for the plaintiffs. None of the defendant. Counsel for the plaintiff submitted. Interim order granted earlier is expiring today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier.
Commercial suit
till 24th of September 2024 and further order whichever is earlier. List the matter on 24th.
My lords, kind leave to mention item 27. My lord, it's a suit for injunction and passing off. My lord, I know tomorrow your lordship does not keep commercial matter. If your lordship kindly makes an exception, and because Friday I have some difficulty, I'm going on a pilgrimage.
Monday come. What is the urgency?
My lord, I will come back on Monday. My lord, can it be fairly at the top, my lord?
My lord, may be permitted to mention item number 20, my lord. My lord, I have got the instruction, my lord, subject to convenience of your lordship, my lord, if the matter can be posted tomorrow, my lord, for withdrawal, my lord, subject to what falls from your lordship.
Tomorrow is not a commercial. Come on Friday.
Friday.
This Friday.